made to the item number 4. I beg to withdraw with the liberty. Some developments have happened.
Right?
The earlier writ petition was dismissed on count number 1, that is the premature, and number 2, that the locus thing was there. It was not a quo warranty, it was a mandamus writ petition. Therefore, things happened. We submitted representation, therefore.
Okay, Mr. S. Banik, learned counsel for the petitioner, submits that he may be allowed to withdraw the writ petition with liberty to file a petition. Who is appearing for the other side?
Till now,
No one. Okay. The prayer of Mr. S. Banik is allowed. Writ petition dismissed as withdrawn, comma, with liberty as please.
wait for public.
Yeah, please, my lord. My lord, I did mention item number 23 of today's list, my lord. My lord, may I kindly pass over the matter for today, my lord. And
Fine.
actually, my lord, there is some correction in the reply, my lord, which I have to go through that reply. my
Some
lord.
correction in the reply. You have got to meet.
I have submitted the reply, my lord, but I need some time to go through that because some minor correction may be there.
Minor correction we can overlook.
Um,
Okay, right. On the prayer for adjournment made by Mr.
P. K. Mazumdar.
P. Mazumdar, learned counsel for the petitioner. This is the matter. After
One.
review.
Please. I take item number 70. I'm withdrawing this petition, my lord.
Okay, Mr. J. Payen. What happened? He's found or what?
My lord, whatever, my lord, the
The husband was missing,
missing letter that found that.
found dead.
So she's getting now pension.
Huh?
She's getting pension now.
He's getting pension. Oh, so okay. I was thinking, why haven't you filed FIR?
No, my lord, at that time he was missing.
So you see, even for a missing person, you have got to file FIR. Then, as per the law, after 7 years, then you're deemed dead.
Yes, my
Presumed
lord,
dead.
that was the issue. After 18 years, he was found dead in a strong pattern. Different place.
Mr. J. Payen, learned counsel for the petitioner, prays that he may be allowed to withdraw the writ petition inasmuch as the petitioner's missing person has been found dead and family pension is being paid to the petitioner. On the prayer of the petitioner's counsel, the writ petition dismissed and withdrawn. Mr.
PN Sharma.
P.N.
PN Sharma,
Sharma appears for the
Education Department, Elementary Education Department.
Elementary Education Department.
May I please, your Lordship?
Huh?
Lordship, with the consent of the council for the petitioner, Lordship, I would to mention item number 18.
18, yes.
1-8, Lordship. There was a direction to produce the record, and today I have received some record this morning, Lordship. I couldn't go through it. Lordship, kindly fix that matter next week, Lordship, on 25th.
Okay, right. Mr. S.N. Sharma,
PN Sharma.
P.N. Sharma, learned counsel for the Elementary Education Department, submits that the records have been furnished to him by the department. However, he needs some time to go through the same.
Lordship.
Accordingly, leave this matter after the week.
It may be fixed minor on 26, because the matter pertains to the non-payment of salary since.
Too many matters being fixed to told by after April. In April.
7.
All right.
May I please, Lordship? Lordship, back to mention for listing, Lordship. Lordship, in this, Lordship, there is an urgency because by private action number 5, Lordship, doing service of teacher, Lordship.
New matter.
No, pending matter, Lordship, pending matter.
Go to the registry.
If the
I beg to mention item number 20.
Huh?
Item number 24, Lordship,
24.
with the consent of the respondent side.
Lordship, I am appearing for respondent number 7, your lord.
Uh-huh.
A date may be fixed, your lords.
No, why do you want adjournment?
I guess something more favored, Lordship.
What is the issue? It's regarding marks, correct? Appointment to assistant professor. Appointment or promotion?
Appointment, lord.
So what are the marks obtained by you? You have no idea. Only came here for adjournment. Who is for the government? Item 24, Higher Education Department. Yes, item 24. What is the marks obtained by the candidates? You bring?
BTC number. It's related to BTC lordship name.
Yes, okay, so
BTC.
who is the council? For the BTC, who's the council for the BTC? You wait, we'll see, you wait.
Yes.
Next,
May I please lordship? May I please lordship? Lordship, I beg to mention an item for listing lordship. There is an urgency in this matter
yeah,
because,
new matter,
yes, lordship.
Huh?
22 matter lordship.
no, you go to the registry.
Urgency lordship because in the last order, it was there. under-
Maybe madam, you go to the registry and tell them, yes, madam.
Please,
Oh,
lordship, my
yes.
prayers for listing lordship regarding compassionate appointment lordship, which was other similar matters fixed on 25th March lordship. So kindly matter may be taken along with that matter lordship.
25th March. Compassionate,
Serious matter.
is it challenging that 89?
Lordship.
So Lordship, I beg to mention item number 15 of today's list.
Huh?
Item number 15 of today's list.
Yes,
We are to file affidavit in reply, but we have not been able to contact the petitioners yet, so we reply to next time.
you're not able to contact the petitioner.
So
This is a 2017 matter, madam. We cannot wait forever. Why 2 weeks? You cannot contact the petitioner. Huh?
we have sent a letter to them.
So if they don't reply, what to do? They're not interested. We'll decide the matter on the basis of materials on record. Why do you want to waste the court's time? If the petitioner is not interested, he's not interested. 2017 matter, madam. Now it's 2025. 8 years have gone. And you want to file affidavit in reply. Yes, who's for the respondents? You wait, we'll see.
I beg to mention for item number 30, my lord.
30, yes.
Once time may be granted, my lord, with the other side consent, my lord.
Your father,
I'm for the respondent number 678.
what do you want to do?
No, I will file reply, my lord.
Reply?
Next.
You're for the respondent.
Yes, my lord. Opposition, my lord.
Who is for the state government? State respondent. Have you filed your affidavit? Item 30.
Yes.
Item 30. You filed?
Next week, my lord, I'll
My
file.
lord, only thing is that, my lord, there is no interim order, my lord, date may be fixed, my lord.
If there is no interim order, then how does it matter? Yes, so you're for the response number?
678.
Mr.
YLE.
Y. Ali, land council for the response number 678 is given 1 week's time to file affidavit in opposition.
Yes.
List the matter after the week.
My lord, may I create date, my lord?
24 matter. Next.
May please your lordship. Back to listing of two matters, lordship. Tomorrow, lordship, because similar matters are already been listed in court number 20 from item 14 to 16. Same matter, lordship, all identically same matter, lordship. That may be allowed, lordship.
Court number?
20, your lordship. Honorable Justice Data Getting, lordship.
So should it be listed there?
It is already listed in the daily list, lordship. Item 14 to 16, I am praying for two other matters, lordship, similar matter.
Along with that?
Along with that, lordship. I have already mentioned it in the mention memo.
Okay.
May I please, your lordship. Kindly the meeting will be passed over for the time being.
For the time being? For the time being.
I think to.
I believe your lordship, petitioner is a senior most science teacher, my lord, the reference number 4, my lord, he is a junior, my lord, but. Your lordship, science graduate teacher, similar, your lordship, already order has been passed in Ramesh Chandra Kakuti on 28 to 2025, order to give.
So?
A similar matter, similar order can be passed, your lordship. Oh, it is 45 here. ছাত্ৰী এটা আছে যে এতিয়াই ক'বা।
So have you applied for the regular selection?
My lord.
Huh?
You has already representation submitted, my lord. Apply to sir. You has applied, my lord. But I have no copy, my lord. Apply কৰিছে যেনেকে এহঁতে কৰিছে লগাব লাগিছিলে।
No, what is your prayer here? Let us see your prayer. Why you should not be? Okay. So you want to be allowed to participate? Right. Heard, Miss
ইয়াৰ লোৱাজি গম এতিয়া তো
N
ইয়াৰ লোৱাজি গম
L Wahida, learned counsel for the petitioner, who submits that the petitioner is a science graduate teacher in Betubari MV School, Karimganj district. And he was transferred to Bonda ME School in Kamrup M district, which was amalgamated with the Raghunath Chowdhury High School in the year 2022. The petitioner is now serving as the senior most science graduate teacher. Good stuff. The grievance of the petitioner is that though the respondent number 4 is junior to the petitioner, the respondent number 4 has been made the in-charge headmaster,
my lord.
headmaster of the school.
Inside.
He's from the other school, respondent number 4.
He is joining this school, my lord, but both the schools are
He's from, it's an amalgamated school, correct? So that respondent number 4 is from the Raghunath Chowdhury school or what? So then what is wrong? In-charge, so he can continue.
My lord, he is the
Next para. The petitioner's prayer herein is that he should be allowed to participate in the selection process for the post of headmaster. Correct? Next, Ms. P. Das, learned counsel for the
1, 2, and 3. Second.
respondents number 1, 2, and 3 submits that in terms of the amendment of the Assam secondary education bracket provincialized schools bracket close service rules, 2018 by the Assam secondary education bracket provincialized schools bracket close service bracket amendment bracket close rules, 2025. Wherein Rule 14 bracket 2 bracket B has been amended, thereby allowing the science graduate teacher to be a feeder post for the post of headmaster, provided he has teaching experience as a graduate teacher for a continuous period of at least 15 years, including the period of service in the erstwhile ME school, the petitioner can be considered for promotion to the post of, can be considered for appointment,
Your lordship, first they have to participate
the selection
interview,
process.
selection process.
That's what I'm saying.
If he is.
Can be considered, I said. Let me
Yes, Your
continue. Can be considered for appointment in terms of the selection process to be conducted by the state government. Next. I have heard the learned counsel for the party. It is seen that the 2018 rules having been amended by the 2025 rule, wherein a science graduate teacher is eligible for selection to the post of headmaster, provided he has the eligibility criteria provided in the 2025 rule, comma. The state respondents shall also consider the case of the petitioner for appointment to the post of headmaster
Science graduate teacher.
in terms of the 2025 rules. If the set post, if the process has. No, that's all. The writ petition is accordingly disposed.
Another similar matter, your lordship, is item 38, science graduate teacher.
So you just say one thing before that, you say, this matter, further, this matter is covered by the order dated 28/2/25, passed in WPC 3820/2020.
And also 3116/2024.
And WPC
3116
3116 of
24, Ramesh
2024.
Chandra Kakati. Another similar matter, your lordship, 38. Science
item
graduate
38, you are in 38 also. 38, give me 38. The case is there, huh? 38. 38,
মই কাৰণে মেইনটো কৰাইছো তে।
out here, how many petitioners are here? Okay, out here. Out here, you're right. Third, which
Seven.
also learned counsel for the petitioners who submits that the petitioners were head teachers of, in para 2 it is there, of schools, prior to the amalgamation of their schools with various high schools. The petitioners being graduate science teachers, the petitioners pray that they should be considered for appointment to the post of headmaster. To the vacant post of headmaster. In terms of the 2025 rules, Miss says that, okay? Others will all remain the same.
Deeply obliged.
What is the other one?
Pending item 1.
My lord. There was a cabinet decision, my lord. Annexure 4, page 22.
Yes,
Page 22, annexure 4.
yes.
My lord, a decision was taken, my lord, to raise the age of retirement of all professors of educational institutions, including the medical colleges, to 65 years.
So,
Thereafter, my lord, I was serving as a principal of a college.
no,
my lord.
so on the basis of the cabinet decision, that is only a decision to raise. Where is the implementation of the decision?
Implementation they have done, my lord. For the University Law College, my lord, the age, retirement age was raised.
No, you are working as what?
I was working as a principal of a college, my lord.
Principal of which college?
Pachim Barigok Anshalik Mahavidyalaya, my lord.
Then
My lord, this decision, my lord, they had implemented, my lord.
let us see the implementation of the decision.
With judgment of the order to. My lord, may kindly come to page 26, my lord.
Yes,
Page 26, my lord.
yes.
Annexure 5, page 24, that is the order of passed in writ petition number 6887 of 2019, my lord. Para 14 of that order, my lord, at page 26. There it finds a mention, my lord, though normally this court would have rejected this petition for enhancement of age of principal of University Law College as he was doing professor's grade UGC scale of pay. The state government has stated that he may be entitled to the superannuation at the age of 65. Then, my lord, I was also directed to submit a representation, para 15. Accordingly, the petitioner may also submit a detailed representation to the authorities concerned as regards the claim for enhancement of the age of superannuation, as had been done in the case of others. The petitioner may file the representation within a period of 1 month from today, and the same may be disposed of by the authorities as expeditiously as possible and before he attains the age of superannuation. So, my lord, as per this order, my lord, I have filed my representation. Annexure 6, page 28 is my representation, my lord. And I have filed series of representation thereafter, which I have already brought in record by way of an additional affidavit also, my lord. And thereafter, my lord, Annexure 7, page 30, my lord. Annexure 7, page 30. With reference to the subject cited above, I have the honor to state that there is no government order till now regarding extension of age of superannuation to 65 years. As you are going to complete 60 years of age on 31st October 2019, afternoon, you will retire from service on reaching the age of superannuation of 31/10/19 positively. So, my lord, what they have done, my lord, that cabinet decision they have implemented, my lord. With regard to others, they have implemented. One case we have shown, they might have implemented for others also.
Show me, where is it? You have not shown anything.
So, my lord, they
You have
done
not
it.
shown anything.
My lord,
You have only said that, you see, after, now you retired when? In 31st October 2019.
19.
Then that's the end of the matter. What remains? There's nothing. You have not been, show me where,
my lord, for the earlier writ petition, my lord, that order which I have shown earlier writ petition, I approached this court. That time, my lord, I was asked to file a representation before the authority. I filed a representation.
Ah.
They have neither rejected my representation nor they have just kept it like that, my lord.
And how they rejected your petition on October 2019.
October,
2019.
no, my lord, they are.
Correct? No, please, let's be clear. They rejected, when did they reject? 24 October. 24 October 2019, they have rejected. And you have come to this court after 5 years, in 2025,
My
after
lord,
6 years.
my lord, I have been filing there are series of representations which I have given, my lord, to them, my lord.
Where's the case? No case. Yes, what about this, what about this WA?
Has been dealt with, my lord.
Huh?
This matter is.
No case. Yes, where?
Sorry, my lord.
In this case, only so many cases honorable court dispose of. Single bench as well as division bench. Division bench judgment.
Anyway, unless he has been, unless there is an order implementing the cabinet decision, they've got no case. They have not been able to show one order implementing the cabinet decision for your college. You have got to show some document that cabinet decision, in terms of the cabinet decision says so, or the government has now announced the age of retirement to be 65 years. You have not shown one document. That is why the court had said you file a representation, let them decide. Who is this person? Another different person.
Different person, my lord, but the issue is
They
same, like,
he
you
was
are-
working as a principal of a private
Yes.
college which was affiliated to. You are also a private college. And then,
So it will be 161. From my from 161.
This slightly different. This slightly different. This slightly different. This is where there's a differentiation between the post of professor and principal. Anyway, the fact remains that here also there's nothing to show that the okay, out here, this is also professors.
Professor, principal.
This is
office
also
at
professor.
No point.
You are what? You are a professor?
Professor, madam.
Huh?
Professor.
Lordship, at not a single person in the Assam Provincial School is designated as a professor.
Show me your
Not a
appointment as
single
a
person,
professor. Show me your appointment as a professor.
Not a single person, Lordship. Till today, not
I
a
want to
single
see.
person, Lordship.
I want to see.
My lord, very good. Appointments are not done, my lord, as professor by professor's grade, my lord. This is the
No,
notification, my lord.
You are teaching where?
College, Lordship.
College, my lord.
You're teaching in the college.
My lord, for professors.
Let us see your appointment order.
Page 13 is the first appointment, my lord.
Page 13. Dr. So is hereby appointed as principal. Of Paschim Barido Anchalik Madhya, what is this? Mahavidyalaya.
Mahavidyalaya, my lord.
A senior, what is this? SR? What is SR? Is it a school or is it a college? What is this?
College, my lord.
It's a college. Okay. This is a college.
Yes, my lord.
Okay, college. Principal of college. Doctor. Your doctor says, sir. His appointment is subject to production of proof of his release from the lectureship. So you are a lecturer. Lecturer means assistant professor.
Not a single person in a college, Lordship, Assam Provincial School is not, no.
Anyway,
Professor.
he is a professor. Let us see. So let us show. Let him show us.
My lord, this is the one, the eligibility, my lord.
No, I'm forget eligibility. I'm talking about you. Show me your appointment as a professor.
My lord, appointments are not as professors, but it's professor's grade. And for that, there is eligibility, my lord.
Professor grade, and you see, You see,
College principal and professor, within bracket, they mention professor's grade. And eligibility is, my lord, he has to be a PhD holder, my lord, and experience of 15 years.
where is your professor's grade letter? Let us see.
No, my lord,
Since you are saying that your professor's
the
grade,
salary which
where
is,
is that?
it is my lord, salary which is.
Mr. Council, SP might be getting the same pay scale as a DC. Does not make the SP a
But he
DC.
meets the eligibility, my lord. That's why he has no.
Right. Heard, Mr.
F Khan, my lord.
Huh?
F Khan.
F. Khan. Learned counsel for the petitioner who submits that a writ she submits that a direction should be issued to the respondent authorities to increase the retirement age of the petitioner from 60 years to 65 years and to reinstate the petitioner in service. Full stop. So what kind of case is this? Anyway, right. Mr. What is your name? Yes, what is your name?
F Khan, my lord.
Mr. F. Khan, learned counsel for the petitioner, submits that the petitioner was serving as a principal in Paschim, Barigog, and Chalik Mahavidyalay, Barangati College. No, Madhya Vidyalay College, Barangati. So he submits that the said college was a private college affiliated with whom?
It's a provincialized school.
Provincialized
Was a
college.
provincialized college.
What university, my lord?
Guwahati, provincialized college affiliated with the Guwahati University. The petitioner's counsel submits that the petitioner is holding the grade of a professor and as such. No, he submits that the cabinet have taken a decision on 19/9/2012 to raise the age of retirement of all professors of educational institutions, including medical colleges, to 65 years.
26/9.
Huh?
26/9.
Sorry, Mr. Council, 26/9 is the letter. The meeting was held on 19/9
Yes, ma'am. I'm sorry, madam.
to 65 years. Accordingly, the petitioner's retirement age should have been extended to 65 years. Full stop. As the petitioner's representation to the authorities for extension of his retirement age had not been decided, the petitioner filed WPC 6887 Act 19. Full stop. WPC 6887 Act 2019 was disposed of by order dated 13/9/2019. By submitting, no, whatever I said, WPC was disposed of by order dated so by giving liberty to the petitioner to submit a detailed representation to the authorities regarding his claim for enhancement of the age of superannuation, which was to be decided by the authorities concerned. Next paragraph. The petitioner thereafter submitted his representation dated 30/09/2019 in compliance with the order passed in WPC 6887/2019, which was rejected by the respondents by letter dated 24/10/2019 issued by the Director of Higher Education, Assam. Which is to the full stop. The letter dated, the contents of the letter dated 24/10/2019 passed by the Director of Higher Education, Assam, states as follows, page 30. Okay. Next paragraph. A perusal, no, next paragraph. The petitioner's counsel submits that that similarly placed persons have had their age of superannuation extended, and as such, the respondents could not have discriminated against the petitioner by not extending his date of superannuation. He also submits that the petitioner having been appointed as the principal of the college, on the ground that no, what have I said? He is deemed to be a professor. That's his case, deemed to be a professor. Next paragraph. Mr. K. Gogoi, the learned counsel for the state respondent. Huh? Okay, Mr.
Yes, that's right.
S. Das, appearing for the Higher Education Department, submits that just because the petitioner has been appointed as a principal does not mean that he is a professor. Since there is no appointment order of the petitioner as a professor. He also submits that the appointment order of the petitioner as a principal clearly goes to show that he was a lecturer, which is equivalent to the grade of assistant professor. He also submits that the present issue has already been decided by the division bench of this court in the case of in WA 161 of 2020. That is Rupam Kumar Brahma versus State of Assam and 3 others, which was disposed of by order dated 1/11/2021. Next paragraph. The counsel for the respondent submits that as no government order has been issued implementing the cabinet decision on dated 19/9/2012 for raising the age of retirement of professors, which in any event is not applicable to the case of the petitioner. The petitioner has no the writ petition has no merit. I have heard the learned counsel for the party. As can be seen from the rejection of the petitioner's representation for enhancement of his retirement age, the stand of the state respondents is that the government has not issued any order extending the age of superannuation of 65 years. When there is no government order implementing a cabinet decision, comma. The same cannot be said to be enforceable in law. Cabinet decision is not enforceable in law. Full stop. This has been clearly laid down by the Supreme Court in the case of Dash versus Dash. I'll give you that later. Have you got the citation? I've got it somewhere.
24 December 1 judgment was come, Lordship.
There is a decision.
Please provide them.
You just give it to me, okay? I've got an old one. I don't have the new.
It's come from the Maharashtra.
Okay, anyway, no, I've got one Supreme Court. Next. The above being said, the fact remains that there is no document submitted by the petitioner to show that he has been appointed to the professor grade at any stage of his life. The appointment of the petitioner as a principal shows that he was appointed while he was in the grade of lecturer, which has been which is equivalent to assistant professor.
He designated as assistant professor.
Huh?
He designated as
Which has been redesignated as assistant professor. As such, the petitioner cannot claim to be in the grade of professor just because he has been appointed as a principal of a college. Full stop. Consequently, even if it is assumed that the cabinet decision dated 19/9/2012 is enforceable in law, the same in any event would not cover the case of the petition. In the case of which para? Next para. Don't say in the case of, you just say. It is also settled law that the question of increase or reduction of the age of superannuation of any government employee rests with the concerned state government in terms of its policy decision. Full stop. In the present case, there is no policy decision that has been implemented by the state government enhancing the age of retirement of the principal of a college from 60 years to 65 years. Full stop. Further, the petitioner in this case has already retired from service on 24/10/2019. So he has only approached this court 5 years after his retirement, that is on 23/7/24 for increase of his retirement age. As there is no order issued by the state government implementing the cabinet decision, no case has been made out for the petition, has been made out by the petition. There being no merit in the writ petition, the writ petition is accordingly dismissed.
Obliged, my lord.
So in this case, my lord, I can one additional affidavit, my lord. Page 92, my lord, regarding the section.
What do you want? You want promotion?
This, my exception, my lord, there is one promotion is there, my lord, selection grade, my lord. That is the pay fixation of not still, my lord, done, my lord.
Page 90?
Page 92, my lord, I actually additional affidavit, my lord. 95, my lord, paragraph 3 and.
No, what is your case? What do you want?
My case is, my lord,
What is your prayer?
My-
In a nutshell, what is your prayer?
prayer, my lord, fixation of pay scale or in selection grade, my lord. And thereafter, my lord, promotion to the associate professor, my lord. It is, both are due, my lord.
To take necessary step for fixation of the petitioner, for fixation of pay. Fixation of your pay scale to which scale? What is the scale that you want?
So, one additional, earlier, additional page 92, my lord. And page 92 to 93, my lord. Paragraph 3 and 4, my lord.
Okay, so you want selection grade pay scale?
Yes, my lord. They already I promoted to selection. Thereafter, my lord, I.
No, you want selection grade pay scale. Huh?
Fixation, my lord, fixation. My lord, that is there.
Naturally, fixation means selection grade,
Yes.
that's all.
Yes,
You want it in some other scale or what? How many scales are there?
my lord, I have already senior grade, I have already got, my lord. Thereafter, my lord, selection grade scale, my lord. They already I promoted to selection grade, my lord.
What is the post you're holding right now?
My, I am, my lord, assistant professor, my lord.
You're assistant professor.
Yeah.
What is the pay scale of an assistant professor?
Yes, my lord, it is, my lord. Yeah, my lord. My lord, it is page 34, my lord.
Yes?
This is my lord, the scale, my lord. It is, my lord. Earlier it was, my lord, now revised, my lord. My lord, dear, my lord, lordship, my promotion was made, my lord,
What is the pay scale given
given, my lord.
to an assistant professor?
Yes.
You see, there is assistant professor, associate professor.
My lord, this.
So what is the pay scale
My lord,
given?
assistant professor, my lord, they have done, their seat, one promotion is, my lord, of some, senior selection, senior scale of pay. In assistant professor itself, my lord. My thereafter, my lord, some, another, my lord, selection grade, my lord.
So
Selection
there is
First, my lord,
senior grade.
first promotion is from a selection, senior scale of pay, my lord. First, thereafter, my lord, selection grade, my lord, pay, my lord.
First is the senior grade.
My lord, yes, my lord, senior scale of.
Now, what is the senior scale of pay? What is the senior scale of pay?
At that time, my lord, right?
At that time, forget at that time, now also.
Well, this my lord, difficult one because I.
It is your case,
Yes.
unless you know the facts of your case. How are you going to convince this court?
My lord, lordship may turn page 64, my lord. This, my lord, my promotion was made, my lord. Promotion was made,
Pay 60?
page 64, next R.
Yes.
And in persons, the government, so and so, my lord, this, on recommendation of meeting of screening committee, CAS, promotion held on so and so, the government higher education department, please to allow CS promotion, stage 2 to stage 3, selection, grade of pay appears in respect of, so and so, 316 numbers of assistant professor, librarian, so and so, as per, so and so, in the pay scale of 15,000, 600 to so and so. Z great pay, my
You
lord.
see, Mr. Counsel, there's no point just reading out. You have got to show this court.
Yes,
At least convince yourself first.
Yes.
What are the various pay scales that is given to this assistant professor? We are on the assistant professors. We are not on associate or professor, only assistant.
Yes.
So assistant professors, there is different stages, correct?
Yes, my lord.
Now, how many stages are there in the senior scale?
My lord, there's first, at the time, my lord, initial, when I got appointment, my lord, it was, my lord, 8,000 to 13,500, my lord. Thereafter, senior scale of pay, it was, my lord, 10,000 to 1,500, 200, my lord.
Show me the list, show me.
My lord, my lord, it is there.
You are rattling off numbers, I don't know.
Yes, my lord, lordship.
What is the basis for you saying all this? Where is the basis?
My lord, then, my lordship, my Annexa A is my appointment letter, my lord.
Yeah.
And my lord, my lord, Annexa D is my pay protection, my lord. 32, page 32. Lecturer, Department of Mathematics, MCQ.
Lecturer is ever protected at the stage of rupees 8 so on so in the scale of pay of so. So this page 32, you are happy with it naturally?
Yes, my lord.
Page 32, you have got no problem with page 32?
Yes, my lord.
Then,
my lord, the page 34, my lord, I promoted, my lord, senior scale of pay, my page 34, my lord.
page 34. Yes.
Page 34, my lord, senior scale of pay is 10,000 to, my lord, 15,200 per month, my lord. This scale is, this senior scale is now getting, my lord.
So you are getting 10,000 to 15,200, but what is your actual pay? How much are you getting? You're getting the scale of pay of so and so, but how much are you getting? Anyway, okay, forget that. You're getting the senior scale of pay of this.
Yes, my lord.
Then now what do you want?
My lord, therefore, my lord, page 36, my lord, my recommendation for, my lord, selection grade of pay, my lord, page 36, Annexa enhancement. My lord, the further Dol Pathak, my client name is Dol Pathak, my lord, senior grade of scale of recommended to be rectified so and so. So selection grade of pay, Dol Pathak is recommended with effect from so and so. So my lord, I'm recommended for selection grade of pay, my lord. And my lord, ultimately it was, my lord.
Just a minute. So page 36. So selection grade pay is selection grade pay. How much is selection grade pay?
Next, my lord, senior scale, next, my lord, selection grade pay, my lord.
How much?
Yes, my lord. My lord, my lord, it is reflect in annexers R page 64, my lord.
Yes.
Page 64.
How much?
My lord, last line, my lord, is in the scale of pay 15,639 9,100, my lord, per month is revised scale of pay 17,9,800 to 2 lakhs 11,500, my lord.
So pre-revised is 15,000 so.
My lord, pre-revised is, my lord, 79,000, my lord.
No, pre-revised is not 79.
Yes, well, 15 minutes.
Now, so what is wrong? So
Yes,
this is
no,
the,
it is okay, okay, my lord, the promotion was given, my lord, but pay fixation was not done, my lord, till date, my lord. My lord, this, my lord, in page 64 itself, my lord, this copy in favor of the necessary action, my lord, this is three, my lord. The principal of the college, she is direct to submit a proposal for fixation of pay in respect of concerned employees, so and so, so and so, so and so. My lord, there is direction to, my lord, now fixation of pay, my lord. I am promoted to selection grade of pay, my lord. This order was passed, my lord, 2022, my lord. 14 February 2022.
what, where is your name?
My name is, my lord, 74, my lord. Serial 21, MC College, Dalpatak Mathematics. My lord, effect was given, it was given from 10/9/2007.
Kamala Das.
First, my lord, my page 74, my lord, Dalpatak,
Huh?
Dalpatak, page 74.
67, you are saying,
74,
that is serial number.
page 74, my lord.
74. So you want this selection grade scale of pay to be applied from
The effect,
from
my
their
lord,
names from 10/9/2007.
yes, ma'am. I've not, still not fixed, my lord.
Okay, so from 10/9/2007, this has to be fixed.
And another thing, my lord, this, their next promotion of associate professor also due, my lord.
That is a different thing.
And my lord, I'm going to retire on next year, my lord, March, my lord.
When is it due?
My lord,
When is it due?
my lord, due immediately after 3 years, my lord.
So that will be so that is as per the CAS or something.
My lord, it is there, my lord. It is-
CS.
Yes,
If it is under the CS, then from the date of their entitlement, they will get it.
yes, ma'am.
So how does it matter? You will get it later on, maybe a little late.
Yes, my lord, I'm going to retire on next year, my lord. Next.
Maybe, but then that doesn't matter because your promotion will be from the date of entitlement. As per the CAS, I think it will be from the date of entitlement. So how does it matter? Even if it's done a little late, doesn't matter. You'll get back. You'll get everything back.
Yes.
Only thing is that your selection grade pay, selection scale of pay has to be given from 2007.
Yes.
That's all. That's all.
And my lord, yes, my lord, then my lord, please, my prayer also, my lord, next promotion is due, my lord. So that is my prayer, my lord. As per my lord, the office, my lord, the state government. This is my lord, page 87, my lord, of the rate, please. So at this stage, notice may we go, my lord.
So you mean to say that you should have been in the selection grade from 2007?
Yes,
Is it?
yes, my lord.
Yes, yes, who is appearing?
Possibly issue notice that this.
Oh, it's
Yes, because the departmental promotions committee.
okay, right, okay, right. Mr. SK may heard Mr. SK Medi, learned counsel for the petitioner who submits that the petitioner was eligible for promotion, eligible for CAS promotion from stage 2 to stage 3 in the selection grade scale of pay of rupees 15,600-39100 AGP 8,000 per month, which was revised to rupees 79,800 -2,11,500 academic level -12 with effect from 10/9/2007 in terms of the notification dated 19/2/22 promoting the petitioner from stage 2 to stage 3. bracket selection grade scale of pay. However, the same has not been done. He also submits that the petitioner is eligible to be promoted to the next higher post of associate professor,
Yes, madam.
which also has not been done. Issue notice returnable in 4 weeks. Mr. Eda, Esda, accept notice on behalf of
1 and 2, my lord.
1 and 2. What about the others?
And 3 years college my government.
Petitioner will take steps for service of notice upon the respondents number 3 and 4 by registered post with AD within 3 days. This is the matter after 4 weeks.
Oh, trustee, madam, trustee.
In addition to the above, the petitioner also given the liberty to serve notice upon the respondents number 3 and 4 through trustee service.
File.
Yes,
I was a teacher assistant teacher of science, my lord, or in a particular school, my lord. Due to some personal reasons, I wanted to get transferred from that school, but that was not done. So at one point of time, I had to submit. I decided to submit a resignation letter. That was done, but that was not forwarded by the headmaster.
resignation letter when?
My lord, I submitted the resignation letter on 31/10/2022.
Yes.
Thereafter, it was not forwarded to the appointing authority, my lord, by the headmaster. But it was representation. My later on, I submitted another representation for withdrawal of that representation.
Resignation letter. Okay, then. When did you submit that?
I have submitted it by next
Page, date. Forget the page. Give me the date.
26/10/2023, madam.
Then
Then,
you were working all this time.
yes, madam.
Okay, then.
Then the headmaster forwarded the resignation letter as well as the withdrawal letter to the director.
When?
Twenty-three, 2020.
22/3/24. Is it?
Yes, madam.
And then?
Then, my lord, the director passed an order
When?
on 22 March 2024. madam.
Same day.
No, my lord,
Because you said that the letter was forwarded to the director on 22/3. So on the same day he passed the order. When?
No, lordship, I am very. It was forwarded on 12/12/2023.
12/12/23. Okay. Then the accepted
was
by the
passed on-
director on 22/3/24. Correct.
24. And subsequently, madam, I filed a representation on.
You were released when? You were released when?
The headmaster of each own released on the very much there when I filed this resignation letter on 31.
10/22. So really back with the backdated. I mean with the retrospective
Yes.
effect.
Yes, madam.
But you worked.
Yes, madam.
Did you work for the entire period you worked? Yes.
My lord, notice maybe is really open.
So you are not getting any pay
Yes, madam.
since 31/10/22.
Yes. So I have filed a representation, my interim payer will be it may be considered.
You see, if the facts are correct, then he's got a case. If the facts are correct. Because prior to the acceptance of his letter of withdrawal, he has withdrawn. Right. Heard, Mr.
Okay, Mr.
M.K. Mishra, learned counsel for the petitioner who submits that in view of the petitioner's request, the submits that the petitioner is a teacher in a school. Full stop. As the petitioner's request for transfer to a different school was not being accepted, the petitioner submitted a resignation letter dated 31/10/2022. Full stop. As the said resignation letter dated 31/10/2022 was left undecided by the authority, comma, the petitioner submitted a representation withdrawing his resignation letter on 26/10/2023. Full stop. The resignation letter and representation withdrawing the resignation letter were thereafter forwarded by the principal.
Yes, sir.
Principal
Headmaster.
of the headmaster of the said school to the director of elementary. What?
Inspector of schools, madam. Secondary school, this is a secondary school.
BTC.
BTC, madam. BTC authority has only director.
So who took the decision to
Director.
accept? The director.
Director.
What have I said? To the concerned authorities. Thereafter, the director accepted the petitioner's resignation letter dated 31/10/2022 on 22/3/24, comma, with retrospective effect from 31/10/22, 21/10, 31/10/22. The petitioner was accordingly released from service with effect from 31/10/2022. Full stop. Next, the petitioner's counsel submits that the petitioner has been serving all along in the school from the date of submission of his resignation letter dated 31/10/2022. And as the petitioner has withdrawn his resignation letter prior to any decision being taken by the authorities, comma, the petitioner's resignation letter could not have been accepted. Further, the salary of the petitioner would have to be paid from 31/10/22 onwards. Issue notice returnable in 4 weeks. Mr. P. Hazarika on behalf of Mr. S.R. Rava accepts notice on behalf of
3 to 6, respondent number 3, 4, 5.
6,
3, 4, 5,
5, 6,
6.
3 to 6. Miss P. Das,
Appearing for respondent 1 and
1 and 2. That's all. Anybody else? No. This is a matter after 4 weeks to enable the respondents to obtain instruction and file affidavit if necessary.
Item 6.
May I please, my lord, this is a covered order passed by my lord. WPC 366 of.
Huh?
WPC 366 of 2025. Lord, the petitioners are working as a tutors, but now they want the pay should be enhanced. Whereas the teacher, my lord, is well qualified. My lordship has disposed of the similar petition, my lord.
Is it correct, Mr. Bara?
My lord.
Okay, out here. How many read petitioners?
Lord, here is 38 number.
38. Okay,
Yeah,
out here you put, instead of Mr. M. Khan, it will be,
AR
AR Bhuyan. Then come, okay. Then everything will be the same. Then out here, for the respondents, it will be Mr.
PK Bora.
PK Bora. PK Bora. For response number,
All the respondents.
all the respondents. Okay.
Bless.
Hello. But the issue is being adjudicated.
Huh?
In this case, is being adjudicated by the Sonal court, my lord.
Has been
Is being adjudicated by the.
adjudicated.
Being adjudicated, my lord.
Where?
Notice has been issued in the other cases. my lord.
Okay, there, similar matter.
Similar matter.
What is the matter, just tell me?
These petitioners are my assistant librarians.
Ah,
Their required qualification for the post of assistant librarian is higher than that of the my lord assistants.
head assistant,
But the salary of the assistant librarians are my lord, lower than the head assistant. And
So-
they have been placed at my lord, grade 3-1, the assistant librarians, and the head assistants are my lord, grade 3-2. Still they are receiving lesser salary. my lord. That is the issue. my lord. What is maybe issue then this?
heard Mr. I. Shakil calls for the petitioners,
Petitioner, my lord.
petitioner, who submits that. The assistant librarian pay should be made equivalent to the pay given to the head assistant.
That is.
Full stop. He submits that the educational qualification required for being appointed as a assistant librarian is higher than the educational qualification required for a head assistant. Full stop. However, the pay of the grade pay of the assistant librarian, what did you say? The pay,
The grade pay and my lord, pay scale. my both.
the pay scale and the grade pay of the as assistant librarian is lower than the pay scale and grade pay of the head assistant. That's all.
my lord.
Issue notice. He also submits, that a similar matter, that is WPC 1417 up to 2025 is pending before this. Issue notice returnable in 4 weeks. Mr. S. Das accepts notice on behalf of
1 and 2.
1 and 2. While Ms. R. M. Barwa accepts notice on behalf of point number 3. Anybody else?
No.
No. List is part after 4 weeks, along with WPC 1417 of 2020.
I think 8 also same, madam.
Huh?
I think 8 also same, madam.
Item 8 was the same,
Same order.
same order.
My lordship, I was originally appointed as a youth school teacher in
Then?
the year 1995. And my appointment was considered as irregular.
Huh?
And my original appointment was considered as irregular appointment. Later on 7/1/2020.
No, what is the issue here right now?
Issue is, my lordship, the impugn order is on page 15, my lordship,
50.
50.
Yes?
No, my lordship. In 550, the Honorable High Court at the Director of Elementary Education to take a hearing and pass necessary order regarding who is the genuine teacher who was accommodated by accommodation order dated, my lordship, on page 43, accommodation order. On page 43. My name is Mainul Lushkar, my lordship. So the accommodation order was supernumerary in nature, my lordship. That is
Huh?
supernumerary in nature, that is.
What is your case here in this? Look, please do not try to go around the bush. Please come directly to the point. Don't waste time.
This impugn order, my lordship, it has been decided that the appointment order neither belongs to the petitioner, neither belongs to respondent number 6. I am respondent number 6 in the earlier writ petition. That is why I am making it. page 51 findings from during the hearing, none of the incumbent could produce that any document related to salary receipt. My lordship, salary receipt, departmental authorities has submitted, my lordship. Salary receipt, how can I submit my lordship? Or training certificate. My lord, it's because I don't have training certificate, that's why I was accommodated as tutor.
So now decision has been taken by the authority.
Yes, my lord.
Then who are we to decide?
My-
You have to take evidence. You go to civil court if you want. How can we decide such an issue? Whether it was you or it was you or the other Moinul Haq.
Error in the,
Huh?
in all my documents, my lordship, in all my documents, which I have annexed.
This is a question where evidence is required.
It has not been considered, my lordship. Only a direction may reconsider my document.
No, no, I think you should go to the civil court. Yes, what to do, madam? I don't know. What is to be decided?
Matter relating to typography, if your lordship is page 51, my lord.
51, yes.
Last para, my lord, however, during examination of the records, my lord, it is seen that
Moinul Haq Vaskar produces original appointment letter. Huh?
1999, my lord, whereas respond number 6, Moinul Haq, both are different person, my lord.
My lord, supernumerary in nature, my school, my lord.
Just
is
a minute, I'm
different
hearing.
school, my
Just a minute. Do not interject her. I'm listening to her. I've given you time. I'll give you time. I've been hearing you. Yes.
And next one, whereas respond number 6, my lord, Moinul Hall Noster produces original appointment letter dated 31/3/1995, my lord. One is appointed in 1999 and others is appointed 1995, my lord. And where the name is written as Moinul, not Moinul, in his In all his other documents, the spelling is shown as minor, so definitely it implies that the original appointment letter issued in the year 1995 is not his appointment letter. Neither the appointment letter belongs to the petitioner Moinul Loscar. He claims to be originally appointed in the year 1999. Also produced the appointment letter pertaining to the year 1999. Madam. Both are different person, madam. It is not a matter of minor spelling mistake. One is appointed in the year 1999.
Correct, there are two persons. No,
persons.
there are two persons. One is Moinul and one is Moinul. One is I, one is Y.
Why?
One is the respondent number 6.
Why?
So the thing is that they were to decide who was the correct teacher. They could not decide. So who are we to decide now on the facts? Evidence will have to be taken.
Well, he should approach the tribunal, madam, educational tribunal, madam.
You can go to the education tribunal. This is a disputed question of fact. We cannot go into this issue.
My lord, kindly see my appointment letter, my lord.
No, I'm not going into that. When this court has already directed that the issue should be decided by the foreign authorities, there is nothing left to
Directed
decide.
the Director of Elementary Education to decide, my lordship.
Heard, Mr.
SB lord.
Huh?
SB lord.
SP Raskar, learned counsel for the petitioner, who submits that the order dated 30/10/2024 passed by the Secretary of the Government of Assam, Department of School Education. Whereby it held that the appointment letter issued in the year 2022 in the name of Moinul Haq, Moinul. You have to be very careful with the name, huh? Moinul Haq Laskar. Neither belongs to the petitioner in WPC 954 of 2023, nor to the respondent in WPC, not the petitioner or the respondent number 6 in WPC 954 of 2023. Full stop. Not full stop, comma, should be set aside. He submits that the respondent number one, who had passed the impugned order dated 30/10/2024, had not gone, had not taken, had not examined the documents submitted by the petitioner herein, who is Moynul Hoque Laskar. Alias no, don't say alias. Your name is there. You had no alias there. Now you're making up alias. Ah. What have I said? Miss S. Tutte, learned counsel for
Order 1 to 5 minutes.
correspondence number 1 to 5. On the other hand, submits that there is no infirmity with the decision of the secretary, decision of the respondent number one, who has to decide as to whether the appointment letter issued in the year 2022 was in relation to the petitioner hearing or in relation to the respondent number 7, comma, MOINULHOQUE, last cap. It happens that the various documents that have been looked into by the authority and the issues that are sought to be, that are being raised by the petitioner hearing are all disputed questions, are all questions of fact which have been settled by the authority.
The other person has already accommodated a tutor, my lord. Page
Huh?
51. The other person against whom the petitioner is claiming, my lord, that person has already accommodated as tutor, my lord.
I am accommodated, my lordship.
Huh?
I am accommodated. I am working, my lordship.
I don't know. That is why you go there. You go to the educational tribunal, all these issues. So why should I
Other
decide?
person, since because he could not take joining, he filed writ petition.
And he filed writ petition.
Because
Huh.
he could not file.
But then out here, the final decision of the authorities is that none of you were given the appointment order.
My lordship, it was supernumerary in nature. That is the original school, my lordship. The person who was appointed in the original school, my original school is 404 Navashantipur LP school. There is no dispute to that. A head teacher has stated that in the year 1995 I joined, and again in 2022 I joined.
What have I said? However, if the petitioner is still agreed by the decision of the authorities enumerated in the impugned order dated 30/10/2024, issued by the respondent number one, the petitioner should approach the educational tribunal. Which educational tribunal? Hailakandi.
Education tribunal, Hailakandi, there is no education tribunal, my lordship.
Educational tribunal, the concerned educational tribunal. I have heard the learned counsel for the parties. The entire controversy is with regard to whether the beneficiary of the order dated 23/9/2022 accommodating the services of what teacher?
Supernumerary.
Oh, you're a what teacher? Subject.
LP school teacher, my
Oh.
lord.
Accommodating the services of the LP school teacher,
Tutor.
LP school tutor,
Tutor.
LP school tutor. In 359, no, in which school?
404.
In 404 number, Nabo Santipur LP school. Was in relation to the petitioner herein, comma, that is MOYNUL HOQUE Laskar, or to the respondent number 7, MOINUL HOQUE Laskar. It cannot be. He is not Hawk, he is HAQUE. You also being cunning, huh?
My lordship, there is, these are all types
Wait,
of-
wait, huh? As it is, HOQU, okay. Video Q Laskar, okay, huh? Laskar. The respondent number 7 had approached this court by WPC 954 of 2023 with regard to the above issue. And this court had taken note of the fact that the petitioner and the respondent number 7 had both presented a claim in respect of the order of accommodation dated 23/9/2022, contending that the said order had been made in relation to them. Full stop.
Respondent number 7, school is different, my lord.
Huh?
School is different. Because he was appointed in a different school in his writ petition.
Anyway, okay, he was with Moinul Haq was with
Original School is different, my lord.
359 chapter Ditar
Yes, his
school.
school is different.
Wait,
My
you are
claim-
different.
my
Okay, what have
claim-
I said? But that is your contention.
No, my lordship, he has submitted that his original school is different. And my
Okay,
school
we
is
won't
different.
go into that. We won't go into, we'll just go into the accommodation part. Huh? What have I said? Claim. Claim.
In the order it is stated, his school is different.
Full stop. As no clarificatory affidavit had been submitted by the state respondents, this court had directed the Director Elementary Education Department to examine the issue on the basis of the available records and to identify the actual beneficiary of the accommodation order dated 23/9/2022. Where is it? Which page?
My lordship, judgment is on page 46.
No. Accommodation letter.
Is on
43.
43.
43.
There are also school name 44.
43. Which states as follows? Huh? You copy it. It is not full. Where is the full thing? Why haven't you given the full one? Why did you give in the full order? It's missing some page, some lines, some words are missing on the left side. Have you got a complete page
My lord,
43?
it is downloaded copy, my lordship. It's
Uh,
like this only, the downloaded copy from the net. Because all the
Page
appointment letters
43.
were.
Okay, anyway, page 43, I downloaded. From here to here, okay. Next.
Here is a school name, my lordship, 44 written. Typography.
This court in its order dated 7/12/2023 passed in WPC 954/2023 also stated that on such identification being made, the actual beneficiary shall be given all the requisite service benefits with effect from the date of issuance of the order dated 23/9/2022. Next para. Pursuant to the order dated 7/12/23 passed in WPC 954 of 2023. The respondent number 1 has passed the impugned order dated 30/10/2024, which is quite exhaustive.
Respondent number 1 was not directed, my lordship.
Huh?
Respondent number 1 was not directed by the honorable High Court.
Respondent number one is representing, he's the secretary. He's the secretary. Right. The perusal of the impugned order shows that a hearing was conducted by the concerned authority and the petitioner hearing and the respondent number 7 were also given an opportunity of being heard. The authorities thereafter came to a finding that the appointment letter issued in the year 2022, it cannot be accommodation letter, it will be a appointment letter, I think. Appointment slash accommodation letter dated 23/9/2022 had not been made, no, in relation to the petitioner or the respondent number 7. And consequently, the appointment letter dated 23/9/2022 was cancelled. Next paragraph. The operative portion of the impugned order dated 30/10/2024 is reproduced herein below as follows. Page 51 to page 52. Okay. Oh. Moinul Haq produced the original appointment letter where his name is written as MOI.
MOI,
Then
my lordship. It's a simple typo because I joined as Moinul. My page 21 may be seen.
this is
In
what
the
is
year 1990, even scrutiny, my lordship, when scrutiny was done,
anyway, list this
the
matter
scrutiny.
on Monday. I'll list this matter on Monday. I have to read it carefully. List this matter on Monday. That we pass that order. I'm thinking whether to dismiss it or to give you liberty to go to the tribunal. Only those two. No other alternative.
Civil court, man. There is no tribunal.
Huh?
There is no tribunal.
There's no, I don't know.
Civil
There's no tribunal, Hailakandi.
education tribunal there is.
Huh?
Headed by the district judge.
District judge, yes, correct. District judge is the tribunal. Hailakandi is a different district.
Yes.
Then. But I don't know, typographical error, where is the question of typographical error?
In scrutiny, my lordship.
Huh?
In the scrutiny, when in 2014, my lordship, the committee constituted by the government issued notice, my lordship. In that, my name, my original name Mohinul was written. And then my joining report also on, in place of I, my lordship, it is Y, my lordship. And always all the documents Y is written. And school name is also 404. The respondent number school is different, my lordship. It's a supernumerary nature.
That school part will have to cut, huh? The school part will have to cut. Those schools, huh? That name, 94 something was said. That part. Okay, next.
Highly obliged.
Thanks, Mr. Lordship.
Item?
Item 10, Lordship.
Yes.
Also, the brief facts of the case is that the respondent number 5, while he was working as an in-charge headmaster of a ME school, he was arrested on 23rd of August 2022 in connection with an anti-corruption case, Lordship. And thereafter, Lordship, he was placed under suspension in the month of September 2022. So immediately after suspension, the petitioner has been allowed to hold the in-chargeship of the particular school. Lordship may find that order of my in-chargeship of the petitioner at page 27 and
Is it an, no, so now,
Now-
it's an amalgamated school.
not amalgamated. Now, what happened, Lordship, during pendency of this departmental process?
So prior to his suspension,
The petitioner, no,
just a minute, prior to his suspension,
Lordship,
the petitioner was the in charge.
no, prior to the suspension, Lordship, the respondent number 5 was the in charge.
That's,
After his arrest, Lordship, he was placed under suspension, and
Suspension.
thereafter I have been allowed to hold the charge.
Okay.
That Lordship will find an annexatory page
correct. Yes.
27.
Then,
Now, during pendency of this departmental proceeding and criminal proceeding, the respondent number 5 is now reinstated in his original post.
so what is wrong?
No, the original post of the petitioner is the assistant science teacher. It is an additional charge without changing or without modifying the in-chargeship order. That is why Lordship may kindly have the order of 20, annexatory page 27. This order was issued until further order. Page 20.
Saila Katun.
Annexatory page 27. May I read the Lordship? As per proposal of the Block Liberty Education Officer Lahorigarh Bhaidi's letter number so-and-so, Mrs. So-and-so, Hindi teacher so-and-so of so-and-so school is hereby allowed to hold the current charge of headmistress of the said school purely temporary with immediate effect under so-and-so until further order or till the regular headmaster is posted, whichever is earlier in addition to his own duties. Vice, this is the respondent number 5, was arrested by police anti-corruption on 23rd so-and-so. This order is purely temporary and terminated without any reason. Now, Lordship may kindly come to the impugn order. Annexure 6, page 31.
Yes.
So I am continuing till there. Now, by this order is issued on by the director on 14th of February 2025, saying that pending finalization of the departmental proceeding, Muhammad so-and-so, headmaster of Hatimuria High School, he is the in charge, not headmaster. Under BO Lahorigarh, Morigaon district, who was placed under suspension issued by the director elementary is hereby reinstated in his original post with immediate effect. Now, my grievance is that his original post is the assistant science teacher. If he join in the post of assistant science, I have no objection. Now, question is.
No, prior to his suspension, he was the in charge headmaster.
Yeah. But thereafter, Lordship, that order is now cancelled by this 20 September.
Well, we will tell them to make a correction of the, you file a, you issue a proper
Yes,
order, let
thereafter,
him.
Lordship, we approach the authority, even the school authority, the managing committee of the authority approach the director, but till they have not disposed of the representation. And even the Lordship, you see the letter of the report submitted by the block elementary, page 47, annexure 11. Till there, I have not handed over the charge. And
You have
after,
to hand over, you have got no right to continue. Once,
no,
you
the
see,
or-
suspension does not mean guilty.
Yes.
Okay, suspension is suspension.
Lordship,
That
he
is
was-
why we have passed so many orders
Yes.
where within 90 days, the suspension, the charge sheet has not been filed. And accordingly, we have set aside the suspension orders and we have asked the officers, the respondents to reinstate the person to the original post.
True.
So he's been done. That's
Original,
all.
that is the
Original post, his
original
or-
post is the,
original post which he was holding, not original post that he was holding.
but without modifying the order.
We'll clarify
itself is the
this.
Order.
I'll clarify this. I'll
The-
clarify, you can
and
clarify.
even otherwise also, Lordship,
No case.
the petitioner is the senior most teacher.
Maybe that is a different thing. That is
this
not
is-
your case.
Lordship,
That is not your case.
yes, Lordship, that is my case, Lordship. In paragraph, Lordship, by 10 years, I'm senior. In paragraph, and Lordship, kindly consider the nature of the Lordship offense.
No, that is not our job.
Lordship, kindly come to.
That is not our job. Our job is only after the inquiry is
Yeah.
completed.
I am 10 years, Lordship, senior to him, Lordship. I am stated in there.
Huh?
Maybe allowed to take his.
No, you see, the thing is that you just clarify that reinstated into the post of
Yeah.
in charge. And then you also say one
Yeah.
small thing, that because of the reinstatement of so-and-so, this petitioner will no longer be the in charge.
Lordship,
Just clarify
Lordship,
that, that's all.
the petitioner is senior by 10 years, then the respondent of 5.
Maybe.
No, Lordship, the insertive is not.
You are from which school?
Same school,
Same school?
yes.
What
In
school?
that- in
What
that
school was that? What school was that?
It's a ME school, Lordship.
ME school.
Hatimuria Colony ME school, Lordship. Lordship, in the same school, I am the senior most teacher. And Lordship must see the insertive, my insertive order, annexure 3, page 23. Annexure 3, page 20. I am the senior most, I am still holding this Lordship share. Page 23, sorry. Insertive order, Lordship. Yes, 27. But this order was issued on 19th of September.
So prior to this 19/9/22,
Yes,
the respondent was the in charge.
the respondent of 5 was in charge. So,
Since when? Since when?
he was after the, it is in 2021, Lordship. He was given this, in the year 2020.
Anyway, we'll let her take up instructions.
And also on the representation filed by
But
the
is
school
the order
authority,
dated?
the members of the.
No,
Urgent.
nothing like that. Heard, mister.
And also on kindly consider. one
Eh,
thing,
they
that I am-
learned counsel for the petitioner.
Because I am senior, but then the responsibility 10 years, Lordship. It is
Yeah.
only in
Just
question.
a minute, can I pass the order?
Sure.
Heard, Mr. A. Dekha, learned counsel for the petition, who submits that the respondent authorities should be directed to review the impugned order dated 14/2/25, issued by the Director of Elementary Education, by which the respondent number
5.
Respondent number 2, my lord.
No.
the respondent number 5
Fine.
has been reinstated to his original post. The petitioner's grievance is that the respondent number 5 was the in-charge headmaster. Was the headmaster? He was the headmaster.
No, in charge.
He's in-charge headmaster of Hatimuria MV School until his suspension due to his arrest in a criminal case. Pursuant to the suspension of the respondent number 5, the petitioner was allowed to hold the charge of headmistress of the school temporarily under FR 49 bracket C and until further order, or till a regular headmaster was posted. The order dated 19/2/2022 allowing the petitioner to hold temporary charge of headmistress. Further stated that the order was purely temporarily and could be terminated without any reason. Next paragraph. The Director of Elementary Education thereafter issued the impugned order dated 14/2/2025. Reinstating the respondent number 5 to his original post with immediate effect pending finalization of the departmental procedure against the respondent. No case, Mr. Kaushik.
Paragraph 8.
The Ms. and Fukan appearing for
1 to 4.
1 to 4, my lord.
I will say issue notice, returnable in 2 weeks. Petitioner to Ms. and Fukan accept notice on behalf of respondents number
1 to 4.
1 to 4. Petitioner takes step for service of notice upon the respondent number 5 by registered post with AD within 2 days. In addition to the above, the petitioner is at liberty to serve notice upon the respondent number 5 through dusty service. List the matter on. 7.
Yeah,
So the petitioner is continuing, Lordship, and he allowed to continue.
No.
I mean, he still he uses
Maybe.
it on the chart. He may be allowed to 10 years in your Lordship.
May I please, your lordship?
Yes.
Lordship petition pertaining to challenging the selection process of the headmaster, lordship. Lordship petitioner is the senior most graduate teacher, lordship.
Science graduate teacher.
Graduate teacher. Lordship.
Science. Graduate teacher.
Graduate teacher, no lordship.
Huh?
Lordship, no lordship. Graduate teacher, arts graduate teacher. And lordship, he was appointed in the year of 1998.
What do you want out here? What?
Lordship, I have challenged the lordship selection process of the headmaster, lordship, prepared by the respondent number 3, lordship.
Why?
Lordship, by lordship throwing away the rules, lordship, rules of 49 section of the Assam Secondary Education Rules of 2018, lordship.
You are a science, you are an arts teacher.
Art teacher, lordship. Lordship kindly say the.
And you are eligible for
post of
taking part, huh?
For the post of headmaster,
So
lordship.
did you submit your candidature? Is it a direct recruitment post?
No, lordship, lordship, for a moment, lordship kindly see the.
No, you see this post of headmaster,
Yes, lordship.
is it a promotional post or a direct recruitment post?
Promotional post, lordship.
Show me the rule.
Lordship kindly see the lordship. It's a 30. Page lordship 34, lordship, and XR 4, lordship.
I cannot read.
Yes, sir, lordship, I am reading lordship.
No, you read it yourself. You take it back and you read it at home. I cannot read. Just look at page 34. How are they allowing this type of filing? I don't know. You cannot read. 34 and 35 is asking me to read. I can't read.
Lordship, Central Lordship. Lordship, in the year Lordship 2023, Lordship final graduation list was prepared, my lord.
This court has noticed that page 34 and 35 are unreadable. The other pages, the other pages also are in a very bad condition and requires some guesswork. Page 34, 35, 45 also. Huh? 45. 34, 35, page 40 and 45. Huh? The other pages are also in a very bad condition. So some registry to ensure that no such unreadable pages should be included in the writ petitions which are filed by the councils for the parties. So some registry shall also direct the council for the petitioner to change the pages, all the pages which are in the back, which are not eligible, which are not legible, and which are in a bad condition. Prior to filing this, trying to listing this case again before this court. List the matter after 2 weeks.
Obliged, Lordship.
Item 12, yes.
The petitioner is your lordship, a guest lecturers in polytechnics, the state of Assam. Now the prayer here that we're seeking by way of this writ petition is that there was a cabinet decision that.
So then they're left out from the
They
three.
left out, they left out where instructions are needed. In fact, your lordship had rendered a similar order in a similar writ petition. Which is, again, the instructions have been sought for. So no
So
instructions.
the notice has to be issued.
Notice
That's
has
all.
to go. Yeah, I'll only pray, your lordship, subject to your lordship's convenience for a shorter returnable date, if possible, because the government is on a war footing to finalize the advertisement. There's no dispute to that. And the petitioners have participated in the advertisement also. Unlike the order that is reflected. In
How many
March.
petitioners are here?
There are 12 petitioners. But there is one fact that I need to state for clarity. My friend has here informed me that petition number 1, without informing us, has also instituted a separate case. We were not aware. Now your lordship will kindly.
Well, now he has informed you.
He has informed me.
Then-
Now, the number 1, petition number 1's name may be struck off. We will file an amended cost.
Why should we impose cost upon him? Why should we just allow him to play around with the court?
There has been.
Have you got the case number?
Yes,
Yes.
1241
1241.
of 25.
1241 25. Just see.
No, my friend is, like the appointment order also. Same petition. There is no dispute.
1241 of 25.
Sabiha Nazni.
There,
Abhinash Das.
Sabiha Nazni.
Sabiha Nazni
Okay, this is out here.
Yes, Abhinash Das is the earlier.
Sabina Nazneen.
with the same prayer, madam.
Same prayer and it has been.
Why shouldn't she pay cost? I think 10,000 rupees. She could pay.
Or maybe we seek an instruction from her on the next occasion, your lordship will impose the cost. On the next occasion, your lordship will impose cost. Maybe we'll seek an instruction from her as to whether there was some miscommunication with the councils or not. Maybe let her come up with an explanation, your lordship.
Everything is supposed to be on oath.
It is. That's why it's
Nazneen.
paragraph 33. We have stated that there is no writ petition filing the same subject
Yeah.
matter.
Sabina Nazneen.
Same appointment order.
Same.
Same.
Daughter of same.
4/8/2028.
Ah, the address also same.
Yes, absolutely. There's no dispute to that, your lordship.
Pin code also same.
Yes. Now, my friend had just informed me. I was not aware of that. There's been some concealment of instructions to us also.
Right. And Mr.
And Sharma.
M. Sharma,
Yes.
learned counsel for the petitioner, who submits that the petitioners were appointed as part-time
Part-time
guests slash
Lecturer.
lecturers
polytechnics.
in, no, on contractual basis in polytechnics. When, in which year?
2018, 19, and 21.
Between the year 2018 and 21.
Yes, two separate advertisements.
Full stop. It pursuant to a cabinet decision dated 24/4/2019.
24/9, 2021.
24/9. How you take this up? Para 2, para 3, okay, para 3. I just stick it up, para 2, para 3, and then I stick this. Mr. S. Das, appearing for the,
All the respondents.
appearing for all the respondents. No, before that, you just say issue notice returnable in
3 weeks, Mela.
3 weeks. 3 weeks. Mr. S. Das, accept notice on behalf of response number
1 and 2.
1 and
All the respondents.
all the respondents. He submits that the petitioner number 1 Sabiha Nazneen, Sabiha has also instituted WPC 2560 of 2025 on the same subject matter initiative. Correct? Yes. No, 2560, WPC.
1 to 4.
Ah.
1 to 4.
Acha, 1241. Registration WPC 1241 of 2025 on the same subject matter edition. Mr. M. Sharma submits that he will obtain instructions with regard to the same. And full stop. He shall also obtain instructions as to why cost of rupees 10,000 should not be imposed upon the petitioner number 1 for having instituted the present suit and WPC 1241 of 2025 on the same subject matter edition. Ashok? 30.
Case challenges the provincialization of the respondent number 7, your lordship. Your lordship shall take note of few dates.
Just a minute.
On 2012-19,
Just a minute.
so that was it.
Yes.
Lordship shall take note of few dates. And not on 3/7/1997. Dhamdama High School, the school in question.
No, you see, let us not go into those. I think the issue basically was that your service was not provincialized.
Yes.
Correct?
I am senior.
Due to there being no feasibility report
Yes, my-
on the subject Sanskrit. Correct?
Yes.
And the respondent number 7, his service was regularized, provincialized, in view of there being a feasibility report with regard to his subject. Correct?
Yes, Lord.
Now, what is wrong with that?
My lord,
Is so the issue is what is wrong, say, with the decision of the respondents? Is it do they have to? Is it a requirement? How many subjects can they have a feasibility report made? First of all, and secondly, whether they had to make a feasibility report on Sanskrit or it is a discretionary power on the authorities or the school authorities to make a feasibility report.
lordship knows that whenever a discretion is exercised, it has to be exercised in a just, fair and.
No, that is. I'm just asking you the question whether it's just or fair. So that's a separate issue. But there is a discretion. That means, is it?
That
Huh?
it's wrong on their part.
Okay,
because-
it is wrong.
Because
Now, so there are various subjects, correct, in a school. So for provincialization, say there science, maths, whatever. There are various subjects, English, whatever, and so feasibility report. Is there any rule which says that the feasibility report has to be made for this many number of subjects or these subjects in particular? Is there something like that?
that has to be answered by the government. State respondent.
No, but then what is your case then? What is your case? Your case is that instead of a feasibility what is your case? That there should be a feasibility report on Sanskrit. Is that your case?
Lordship, I joined in 18/8/1998. Dhamdama High School, the school in question. And prior to that, on 3/7/1997, when the school was upgraded to a higher secondary school, it was done after the scrutiny of inspection report of 98 institutions. And 55 high schools were recommended by the government for upgrading them to higher secondary school on the basis of a necessity come feasibility report, on the basis of on-the-spot inspection that was done there.
These are government schools or what? Or provincial schools? What is this?
So
Huh? Venture school.
it has now been provincial.
At that time, it was not. So,
So when the school was upgraded, it was done on the basis of a necessity come feasibility that was done on the basis. of the
you see, the issue is this.
Yes, my lord.
Supposing a venture school has got 50 teachers or 1,000 teachers teaching various subjects. When there is a provincialization of their school, can the authorities say that only this many teacher services will be provincialized? Only these subjects, only these subject teachers will be provincialized. Can it say that? So it has to provincialize everyone, according to you.
Cannot be done arbitrarily.
That is a different issue, madam. Please don't, you're thinking of only, you're looking at with blinkers. You know, a horse has blinkers, you cannot see anything but in front. I'm not on that. I'm not on whether the decision is correct or not. I am asking you a certain, your views as per the law. Whether in provincialization, while provincializing a school, on the services of the teachers there is it a requirement that 100% of the teacher services have to be provincialized?
It has to be done on the basis of the application being made. Whether the application was being made for that.
What does the rule say? What does the law say? That's what I'm asking you, madam.
Yes, my.
Yes, Mr. Kaushik. This case, now what is the
Basic challenge is to be the speaking order passed by the Director of Secondary Education rejecting the claim of the petitioner on the ground that the petitioners, the subject the petitioner was teaching in that school, they did not have the feasibility. So there is no contrary record produced by the petitioner saying that this order is wrong because there is a feasibility report. And this is an
there's a
undisputed-
feasibility report on what?
No, it is
There's a feasibility report, but not on the subject.
not on
of-
the subject the petitioner was teaching.
So,
So it's an undisputed fact, my lord, that the subject which the petitioner was teaching, that subject did not have the feasibility report. That did not have the.
so
concrete-
where is it a requirement under the rules that there has to be a feasibility report in respect of a
My lord,
particular subject?
the 2011 rules, my lord.
11.
Six five zero, my lord.
Yes.
650.
Section 4, my lord. Employees to be government.
Just a minute, madam, I'm asking him. Don't interject. When I was asking you, you couldn't answer. Now I'm asking you, you're interjecting. Don't do that.
My lord, to find this first C650, page 650Q, the definition of venture higher secondary school.
Yes.
Means higher secondary school imparting education up to class 12 and established by the people of the locality on or before 1/1/2006, which have received permission from the state government on or before 1/1/2006 and not provincialized under the act and earlier enacted by the state legislature so far, and it includes junior college also. Now, this permission, the institution must have a permission prior to 1/1/2006. Now, my lord, you kindly see 3 subsection 2 at page 650 from 1 method. The eligibility criteria.
Yeah.
Subject to the provision of Article 30 of the Constitution of India, the following categories of venture education institutions shall be eligible for being considered for provincialization of services of its employees. The venture education which have been established and have obtained required permission or recognition and affiliation or concurrence, as the case may be, from the respective competent authority or authorities on or before 1/1/2006. It has a minimum total enrollment of 25 students. If it is a primary school, this is not applicable. Now, 2, my lord, subsection 2. In case of a degree college and a junior college, the eligibility criteria should be above regarding of recognition, affiliation, and concurrence. Now, my lord, the feasibility report is important for getting a concurrence, and it's an undisputed fact, my lord. That subject did not have the concurrence from the higher secondary council, my lord.
Where is the concurrence required?
The subsection 3, subsection 1, Roman 1.
No, this only talks about they shall be eligible for being considered for provincialization. If they have
Of services of its employees. That institution must have a concurrence prior to 1/1/2005.
so this does not talk about subject.
No,
It's not subject wise.
the concurrence is given in respect of the subject.
So let us see where is the
That, my lord,
concurrence of the subject.
Sebar higher secondary college. Like 2-6.
So basically, that permission or that concurrence for the subject, where is that? Where is the requirement of making a feasibility report on a particular subject?
The feasibility report is not so specific in the rule.
No, but then yes, I understand there has to be a requirement for a subject.
Quite subject.
But who is now, can a feasibility report be given for all the subjects? Why only for some? And of course, the number of teachers that can be provincialized, that might have a bearing. I do not know how many teachers can be provincialized.
That is as per the schedule given in the
So,
act.
So maybe that can have a bearing also. We'll have to see. So that is the issue basically, because the reason that the petitioner has not been provincialized is due to the non-feasibility report not being made.
The schedule that is given under the 2011 Act is, my lord, at page 663.
Yes.
This was the maximum cap.
Which one? Which one? Degree college, junior college, where are we? Which one?
It's higher secondary.
Higher secondary. So you see, 7 for arts, 7 for science,
arts, 7 for science,
so 20.
6 for commerce.
Then
three.
demonstrator 1, senior assistant 1.
One.
So
Laboratory
teacher, you have got 20.
20.
Now, for 7 for arts, 7 for science.
Pilot.
Now, Sanskrit, what is it? It's a arts.
Arts.
If it's art, now for the school, how many were provincialized in arts?
Response 6.
I think
Page 111.
I think you all need to. Let us be very clear about the contours of this case.
See, 1, 2, 3, 4, 5, 6 teachers were provincials
For arts.
for arts.
Then that means 1 remain.
1. And that it was 6 initially. Later on, subsequently, 1 post was allotted.
Okay.
Which is a subject matter of challenge here.
Okay.
Which was allotted the post of logic and philosophy to the private respondent.
So logic and philosophy, here the.
Here.
So there was a feasibility report made with it.
Well.
So feasibility report was not made with regard to Sanskrit. What do you understand by a feasibility report?
Or the Inspection report. So this is the precondition for giving a concurrence to that subject.
Where does it say that?
That higher secondary council.
Where does it say that that an inspection report has to be given?
The higher secondary education.
And
Council
why,
Secretary of
I don't, how I should have, how can a feasibility report be the same as an inspection report? Inspection is inspecting. They could have said inspection report. You cannot give a different meaning.
The page 41, my lord, to kindly see.
Page 41. Page 41 of
Page
the writ
41
petition.
Of the writ petition.
Yes.
Page 42, item 7. Consider permission for inclusion of the subject which was left out when the feasibility reports were sent to the government. Here, my lord will find at serial number 8, the Domdoma High School, Nalbari, Logic and Philosophy. That was left out then, my lord.
So it was left out.
Yes,
Logic and philosophy were left out.
left out.
Therefore, how do you
And-
say that feasibility report was given?
No, subsequently,
Subsequently made.
yes.
So that means you'll have a discretion to choose the subject, is it?
Yeah.
How do you say that you're going to, how do you,
That,
how do you choose a subject? Or is, supposing school is to be provincialized. Supposing the authorities have the right to choose their subjects, can they say, okay, we don't want science, maths, geography, or history to be there. We want
Considering-
all Sanskrit and all those.
Considering the number of the students in.
So what I'm trying to say is, do they have a choice in considering which subjects to be taught in the school or not? Or they don't have a choice?
It's based on the students, number of the students in
It-
that school.
Okay, based on the students, okay, students, there are enough students, more than 200, say, in the school. But for provincialization, they've qualified as per the schools, as per the student number, population. Now, with regard to the subjects to be taught,
For provincialization, we look into that whether that subject has got a concurrence before 1/1/2006 or not.
that
Now-
subject has got concurrence
Subject has got concurrence or not.
before 2006.
1/1/2006.
So, out here, logic and philosophy, did it have concurrence prior to 2006?
Yes,
Where?
was. Respond number 7.
7
The minutes of 2012.
No, you see, probably both of them don't have. Sanskrit also didn't have. Logic and philosophy also didn't have.
Hmm.
My question is, do they have the discretion to choose which subjects should have a feasibility report?
No, the authorities under the department, my lord, has to go with, in respect of the act, that it has got the concurrence or not. Now,
I agree.
subsequently, I mean, initially, the logic and philosophy was also left out.
Correct.
Yes, and thereafter, there was a concurrence given by the.
No, you see, please don't try to sidestep the issue. The issue is this. There are certain subjects taught in the school. For provincialization, for concurrence, we need to have the school has to take the concurrence of the government.
From the higher secondary.
So can the authorities choose which subjects need concurrence and which subjects they don't want concurrence?
The concurrence is given by the Assam Higher Secondary Education Council.
Agreed.
Yeah.
So, okay, so school has got no authority.
School has got no.
So
School will apply for the concurrence.
that's what I'm saying. Does the school have the discretion to apply for concurrence for certain subjects only, or it has to apply for all subjects?
No, school have the number of students in that subject. If that subject has got students, then the school will have to apply.
Can apply, or will have to apply?
Will have to apply because unless that subject has got concurrence, that they cannot.
Okay. So that means that that means at the time the concurrence was sought for the other subjects. Logic and philosophy was not there.
Logic as philosophy was left out from giving.
Why? Because you said that it must have.
It must
So it
have.
was left out
And it was
for a
applied.
reason that, according to you, it implied that he did not have enough students. Naturally.
Student was there.
Now, no, yeah, miss, you are both on a different boat now. He's saying that no, if there are students, they have to apply.
Yes,
So
yes.
because they didn't apply, it implied that they don't have students.
No, the item 7 at page 42, the minors, it shows that due to feasibility report sent to the government, that it was left out. So meaning thereby, by the application was there. And therefore, my lord, the subsequent paragraph. No, my lord, it's kindly see the paragraph 42, page 42, subsequent paragraph. The secretary placed before the committee that the application in the matter for inclusion of the subject which was left out when the feasibility reports were sent to the government. In this regard, the committee arrived at a conclusion that as the feasibility report forwarded to the government does not mean according permission to the subject from the council. So the council will not entertain to send any report again to government as per their applications. However, the council will accord permission as soon as the posts are created by the government and the appointment is concerned subject are made by the government in case of the government institution. Now the post subsequently was created allotted on 17 December 2014. That is page 40.
You see, it says that it was left out when the feasibility report was sent.
Yes.
Does it mean that there were enough students or there were not enough students?
Enough student.
How do you say that? How does it mean?
Well,
Feasibility report, where does it say that feasibility report would mean a report? Is there a definition of a feasibility report? Yeah, how do you say that a feasibility report means a subject wherein there are enough students as required under the Act? You cannot put words into the mouths of the provisions of a statute as you want. Tomorrow you say that means a mitha pan or something like that. Cannot be. It has to
Act
be.
of 2011 is silent about.
Then
that's why actually this act of 2011 there is some various ambiguity. That's why it was cramped down in the earlier question. And my lord, the division bench judgment, that's why says my lord.
Okay.
Not there, my lord, in respect of item number 22, my lord, that matter might be taken their side.
You have brought the marks.
Yes, your lordship. On last occasion, your lordship had directed to protect the record, your lordship. Department has already filed affidavit, your lordship. It was filed earlier and in that affidavit, they have particularly stated the marks which.
Then why?
They only day after tomorrow, my lord, because perhaps the petitioner side will appoint another, they do not have confidence on me, my lord. So only for the day, my lord.
Item 22. When did you file affidavit?
No,
They filed it.
Department have filed.
When?
It was filed earlier. Your lordship.
When?
It is already in the record.
Issuance of notice, my lord.
At the time of issuance of notice.
A long time back.
Yes, your.
Then what remains?
Then they only day after tomorrow. Before today, my lord.
Give me, show me. No, just show me item 20. This is the affidavit of whom?
Respondent number two, Director of Elementary Education. It was filed on 10th of January.
Respondent number?
Respondent number. Two euro.
Huh?
2 euro.
Marks are here. Records, who is for the respondent? Anyway, we'll see, let the case come on time, we'll see, on that time.
My lord, I have here, on last night, my lord, they have instructed me not to appear in this case on their behalf. They will appoint. For that reason, my lord, I am seeking on.
We will record your submission. That you have been asked not to appear. Item? Ah. Yes. Now, where is the impugned order?
The impugned order is at page 40.
40?
39.
39.
39, 40.
39 and 40.
Let us see this order of the High Court, 21/5/14.
21/5/14.
WP 4422 2013. Page 38.
Page 38. 37, the order starts from 38.
Yes. So page 38, what was to be decided?
My lord, the decision with regard to whom to be provincialized,
Correct.
because there was an interim order which
Her case was that it has to be based on the basis of seniority.
based on seniority.
And you
Now
were
that-
on the basis of the subject.
Yes, but that seniority will come, my lord, only when it is in respect of a particular
Subject.
particular category, the subject, respective post. Had these both the petitioner, the private respondent and the petitioner
Since her subject was not accepted.
not accept. But if your lordship will kindly see, my lord, possibly it would be relevant. Page 525 of the manual, my lord. This is the
Page
regulation.
525.
525.
Yes,
This is the regulation on recognition of higher secondary and junior colleges. This is the regulation which governs the recognition and permission by the secondary council. Now, my lord, will kindly see 527 section, regulation 3.
yeah,
There is a requirement of taking permission from the council to start a class. And the council,
yes,
yes, sir. The council shall scrutinize every application for permission to start a class in a proposed higher secondary junior college and examine the information furnished by the sponsoring body in the application with the particular reference to the initial requirement as laid down in sub clause 2 above. The regulation on a satisfactory report. Now, this term satisfactory report possibly is which is being used as a feasibility report. The council, Malad, the regulation 3. The council shall scrutinize every application. May I just start from 1, my lord, first?
yes,
Regulation 1. Where when it is proposed to establish a new higher secondary school or junior college, or to upgrade an existing high school already recognized by the Board of Secondary Education to a higher secondary school, or to open a new stream or subject in an existing higher secondary school, recognized by the Board of Secondary Education or Higher Secondary Council, as the case may be, the sponsoring body shall submit an application to the Secretary Higher Secondary Council. Now, the later portion deals with how the applications will be made. Now, regulation 3, while granting the permission, what are the requirements? The council shall scrutinize every application for permission to start classes in a proposed higher secondary school or junior college and examine information furnished by the sponsoring body in the application and with the particular reference to the initial requirement laid down in clause 2 above. The council on a satisfactory report obtained through its own agency on an initial, Malad finds that satisfactory report, through an own agency on an initial requirement as per clause 2 and on verification of the particular furnished in the application, may grant permission to open a new high secondary school, junior college, or to introduce a new stream subject in an existing high school, junior college on individual merit. So what I'm trying to impress upon, Malad, that the permission to
open a
that-
subject.
Yes, to grant that permission.
To run a subject.
There has to be a report that is to be prepared by the Higher Secondary Council by its own agency. Now, that is what is perhaps is indicated as a feasibility report.
Has to be.
Yes. And the 2011 rules otherwise, it says it needs to have permission prior 1/1/2006, concurrence permission to 1/1/2006. Now, the day when the consideration was given to that school for bringing it within the ambit of eligibility, the subject of the petitioner did not have the permission. Even today, it did not have the permission.
Even today, it doesn't have the permission to run the school.
There's no permission.
Run the subject. The concurrence of the state government is not there.
Yes. And therefore,
the school has started the subject.
School has started.
But the government has not given the concurrence to run the subject.
Possibly, this school has students also for that subject. And therefore, she has been continuing teaching in that school. But the basis of this rejection in the speaking order was there was no feasibility report at that point of time. And which otherwise is not incorrect, as has been could be proved by the petitioner. So this is one method. Second method, there is one prayer for setting aside the speaking order. Now, to set aside the speaking order, the petitioner has to establish that this is an incorrect fact which has been, whereby her claim has been rejected. Second method, there is a mandamus prayer for provincializing her services. Now, as the 2011 Act already been struck down, so perhaps in terms of the judgment of the Honorable Division Judge Purnamati Brahma and other Supreme Court judgments, that once the act is struck down, there cannot be a accrued right or a right which enforceable right to be claimed. So the only, if I may say so, the only remedy what the petitioner has, because the new act after the 2011 Act was struck down, the 2017 Act has been brought in, wherein the teachers who were left from provincialization under the 2011 Act were also given a consideration. So petitioner may apply under the 2017 Act, and if she is found eligible under the 2017 Act, that consideration can be given by the government. If there are students, because that would be the criteria under the 2017 Act. There has to be a minimum students for a particular subject for provincialization.
That can be done.
You'll apply.
Yes.
You can apply, but whether they'll agree or not, that's a different issue.
That has to
With
be
liberty.
that has to be examined under the Act of 2017.
Because you see, at the end of the day, the feasibility report is a requirement because the school has to run on the basis of certain subjects and a number of teachers. And as per the schedule of the 2011 Act, you can provincialize only 20 teachers. So that shows that you cannot provincialize all the teachers in a school.
Yes.
Now, that being said,
in fact, that was one of the challenges to the validity of the Act.
that being said, which subjects are important to be taught, that is again a consideration. Because you can have in a certain school, this is a school or college?
It's a higher secondary school.
Higher secondary.
So in a higher secondary school, you see, there might be English, alternative English, second language, third language also could be there. So whether all these subjects are required and can come within the financial capacity of the authority also, that will have to be looked into.
Yes.
So there's nothing wrong in choosing which subject should be taught in terms of the importance given to the state government. State government will naturally say that you cannot leave out maths or you cannot leave out science. You cannot ask for some other subject which is not there. So it seems that your case is slightly weak, your case, that way. So 2017 you apply? But I'll have to mention everything, that means.
Lordship had already passed. the-
Pass an order, but I have to
Yes,
pass longer, I'll have to add some more. You're right. The counsel for the respondent submit that the impugned order dated 25/11/2014 issued by the Director of Secondary Education had been made in pursuant to the order dated 21/5/2014 passed in WPC 4422 of 2013. Wherein the matter was left open to be decided by the Director of Secondary Education as to whose service should have been provincialized. As stated in the foregoing paragraph, the service of the writ petitioner could not be considered for provincialization as there was no feasibility report made in, for the subject Sanskrit. He submits that the petitioner has not been able to show as to the as to whether the order dated, impugn order dated 25/11/2014 is unreasonable or unfair. Full stop. He also submits that in terms of section 2 bracket Q and section 3 of the 2011 Act, concurrence/permission for teaching a particular subject in the school, in the higher secondary school needs to be taken from the state respondents. Full stop. However, there is no permission/concurrence taken by the said school for teaching the subject Sanskrit even till today. Full stop. On the other hand, when a feasibility report, what about for logic, and it was given?
It was given in 2012.
Full stop. However,
2014.
concurrence for teaching the subject logic and philosophy was given on
2014.
It was given on, my lord,
was given on
26/07/2012.
26/07/2012. And as the provincialization of teachers could only be done in terms of the number provided in the schedule to the 2011 Act. There was no infirmity with the respondent authorities limiting the number of teachers that could be provincialized and the subjects which were to be taught in the provincialized school. Next para. The counsel for the respondent submits that as the 2011 Act has been struck down as being ultra virus by this court. Huh? In
No.
in where in which case?
Judgment and order dated 23/09/2016.
In the judgment and order dated
23/09.
23/09
2016.
2016.
WPC 3190 of 2012.
Passed in WPC 3190 of 2012, comma. No further Proceedings can be initiated in terms of the two thousand 11 Act. However, as provincialization can still be considered in terms of the Assam education bracket provincialization of services of teachers and reorganization of educational institutions bracket close Act, 2017. Hereinafter referred to as the 2017 Act, comma. The petitioner may make an application for considering provincialization of her service in terms of the 2017, comma, which will be decided by the Director of Elementary Education, is it?
By the two committees are there in the.
By the two, in terms of the provisions of the 2017.
2007.
Next, I have heard the learned, no, next. Should I give my decision or should I, or you're going to say that you're not going to press? What are we going to do? I can do both, no problem. I can give my decision, but it will go against you.
Lordship, then in that case,
So you can say that you will not press this matter and instead you will approach the authorities.
yes, Lordship,
Better, huh?
liberty to approach.
Next, at this stage, Miss B. Whatever. Miss B. Chowdhury, learned counsel for the petitioner, submits that he does not wish to press the present writ petition in as much as the 2011 Act has been declared ultra vires by this court. However, the petitioner may be given the liberty to approach the respondent authorities for provincialization of a service in terms of the 2017 Act. Pusta. Anything? Nothing. Next.
Yes, Lordship. Particularly in view of the fact that the headmaster of the school had written to the authorities at page 50. of
Page
the
50.
petition,
Ah,
That the subject.
particularly when the headmaster, is this headmaster or what? In charge, in charge principal
Yes, Lord.
of the, what school is this? Damdama.
Higher-
Damdama Higher Secondary High School has written a letter dated 30/11/2012 to the Secretary Assam Higher, to the Secretary of the Government of Assam Higher Education Department.
No, it's a Secretary Assam Higher Secondary Education.
Oh, Council.
Council.
Written a letter to the Secretary Assam Higher Education, Higher Secondary Education Council, Bamudi Maidam, Guwahati,
Respondent 6. Lord.
informing him that the subject matter, the subject Sanskrit is taught in the school since 1808-98 and that a feasibility report was required on the subject. Full stop. Next paragraph. In view of the submission made by the counsel for the petitioner, comma, this court is not deciding the writ petition on merit. However, the petitioner is given the liberty to approach the respondent number
6.
6 or to whom? 6 is only, huh? 6 or 2?
The inspector of schools, because for provincialization, they will have, the petitioner has to approach respondent number 3, because respondent number 3 is the member secretary of the district scrutiny committee. But for feasibility report, Perhaps 2017, like this feasibility report is not required. Lordship will not record that.
Yes.
But Lordship.
So whatever I said, is there any feasibility report required? How to-
Now it's not.
Whatever I said? The respondent number 3, that is the inspector, respondent number 3, who is the member secretary
Of the
of
district.
the district scrutiny committee. Uh, with regard to her prayer for provincialization of her service in terms of the 2017 Act. So thereafter, a decision should be taken by the respondent number 3 within a reasonable period of time and not later than
Or your Lordship will say that the respondent number 3 will place it before the district scrutiny committee to take a decision.
okay.
within a period of-
The respondent number 3 shall thereafter place the petitioner's application with before the district scrutiny committee within a period of
3 months.
3 months from the date of receipt of a certified copy of this order. And the DSC shall thereafter take a decision on the same. The writ petition is accordingly disposed of. Wait. I will be in view of the order passer. Then out here, Miss B. Chowdhury, Miss B. Kaushik is here, Mr. C. Goswami is here, Mr. D. K. Roy, no.
Respondent number 6.
Yeah, Mr.
TK.
Your name is here already. Order dated 17 to 25. 75% of the work already done here.
District scrutiny committee, Nalbari.
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 Lordship, may I say that a liberty be given, if so aggrieved at a later stage?
It is there.
That is always there.
For appellate already there. Yeah, it's.
Okay, that's right. She wants it for her client,
Yes.
not for herself.
Yes.
It is needless to add that if the if the petitioner is agreed with the decision taken by the district scrutiny committee, the petitioner the petitioner can always make a challenge to the same as per law.
Here I'm paying for 10 days time. I have my affidavit.
Mr. Alright, 10 this time, what is this? 17 matter, Mr.
Malad,
Counsel?
what happened, Malad, here, there are 5 petitioners, Malad.
Oh,
Out of 4 petitioners, 4 petitioners has already been accommodated as tutors and they have accepted the condition that they will forego their past service.
Okay.
Now, one petitioner, he was accommodated, but by the time he was accommodated, he has gone on superannuation.
okay, so
So now the claim in respect of his salary
Ah.
would remain. Malad.
okay.
We have no objection regarding that, but in a period of 1 week to 10 days, the date may be fixed.
Have you so you see,
Possibly they
Have
will
you-
also have to amend the writ petition.
have you amended the writ petition? Because those, you see, those parties, those which petitioners are not agitating this issue?
Petitioner number 1 to 4 is not hesitating the issue.
Only 5.
Only.
So you have to change that. Right. Right. Mr. B. Kaushik, learned counsel for the respondent, submits that the petitions number 1 to 4 are not pressing the issue any further, as their grievances have been met. On the other hand, the petitioner number 5 had retired, had reached the superannuation age.
Yes.
By the time he was offered the post of tutor,
Tutors.
and as such, the issue only pertains to payment of arrears salary to the petitioner number 5. Miss
G. Duggar.
G.
Duggar.
Dugal,
Duggar.
Duggar, learned counsel for the petitioner, submits that she'll file application for amending the writ petition. This is the matter after 2 weeks. In the meantime, Mr. B. Kaushik shall file his affidavit in opposition. You file an application because you see, 1 to 4 are not, they're not pressing the matter anymore. Item 15. Yes,
Require 1 week time at least.
to what? To do what?
Letter to them. 1 week time may be given so that they can refer back
Miss?
as saved in on behalf of NJ Gogol.
Ah. Submit that they have not been able to communicate with with the petitioners for some time. He accordingly prays for a week's time to try and communicate with the petitioners. List the matter after a week. The matter pertains to
Non-payment.
non-payment of
arrears salary.
arrears salaries to the stipendiary teachers.
Not stipend regular. These were the teachers who were illegally and irregularly appointed, and thereafter they have been accommodated.
Okay.
Now we have accommodated this petitioner also.
Okay.
Now possibly they have accepted the appointment, and if they have accepted that condition that they,
Without their past pay.
Yes, past
Okay, right. Whatever I said.
and in our affidavit we have
The pertains to not payment of the salary to the petitioner. Do you list them, give a date? Give a date. Oh, that's the correct item. Item? 60. This is infructuous, I think. Huh? But no one has come anyway, right? No one appears for the petition on call. It is seen that no one had appeared on behalf of the petitioner since the year 2020. Mr. B. Kaushik submits that the writ petition has become infructuous. On considering the fact that no one has appeared on behalf of the petitioner, the writ petition is dismissed for non-prosecution. Out here, your case is that the petitioner's regularization order is fabricated. In para, I think in para, where have you mentioned it? Yes. Accordingly, para 6, accordingly, a directorate level inquiry had been conducted. And from the findings of the report, it appeared that the regularization order in respect of the petitioner is fake and fabricated and were not issued from any competent authority of the Education Department. Right. No one appears for the petitioner on call. The petitioner's case is that the impugned order dated 25/10/21 granting approval for cancellation of the petitioner's service had been done in violation of the Assam Services (Discipline and Appeal) Rules 1964. Para 6 of the affidavit of the respondent number 2 is to the following effect, page 73. We'll give one more, I don't know, they come off and on, and then last time they appeared.
he was there. The first half he was there when he appeared.
He was here, no?
He was there.
List the matter on next week. Full stop. If no one represents the petitioner on that date, the matter will be decided on the basis of materials on the court.
Here, my lord, we have to reply to the affidavit filed with the respondent number 2, my lord. So,
Mr. M.R. Khandakar, learned counsel for the petitioner is granted
2 weeks.
2 weeks time to file affidavit in reply. List the matter of 2 weeks. Give a date.
And every month.
Seeking 10 days time to file affidavit in opposition. Your Lordship.
Yeah, for whom?
7 and 8. Respondent number.
Mr.
R. Borman.
Counsel for the respondent number 7 and 8 is granted 2 weeks time to file affidavit in opposition. This is the matter of 2 weeks.
22.
Who is for the government out here? Madam, you're there. So what is the issue here? Marks or what? That's only marks, no?
Annexed which they have annexed the writ petition, your Honor. On that basis, our selection has not been done, Your Lordship. We have submitted the marks obtained from the.
No, have you brought the records,
Yes, Your
madam?
Lordship. It is on the basis of the record. Affidavit has also been filed.
But this court has asked for the record. I want the original mark sheet. What is cough? Dry cough. Have one. Hmm. No one appears. What is this again, marks? This is for assistant professor, correct?
Assistant professor.
Then the selection is made on the basis of marks.
Yes.
Is it? Then so what is the petitioner's case? What to do? He is not here. There is a problem.
Moreover, BTC stand will also be required. BTC.
Huh?
BTC stand will also be required here.
Who's for the BTC?
Petitioner is also not another.
No one appears for the petitioner on call. Accordingly, list this matter after the week.
Your Lordship, the leading counsel, Mr. A. Sharma, is unable to appear before his court. He's out of station. He may adjourn this matter.
Okay, who's appearing for the other side? Yes, who's for the secondary education? Are they having a meeting? A meeting? Meeting finished till 2:30. Huh? They should give some here also. Tea and samosa. Okay, right, on the prayer for adjournment made on behalf of Mr. A. Chamwal and counsel for the petitioner. List the matter after 3 weeks. In the meantime, the respondents may file their affidavit in the position. Next.
26.
Hello, in this matter, a hearing has been scheduled on 25th, my lord.
What hearing?
Regarding this matter.
Regularization of debt period of suspension.
How can you challenge their decision to conduct a departmental proceeding?
My lord.
What right do you have?
My lord.
They can do it. What right do you have?
Complete the departmental
Huh?
proceeding as they should conclude the department because I am.
Or they have not concluded it. That is your grievance. Is it?
Because I have been recommended for promotion to headmaster.
No, you might have been promoted, you might have been recommended. Has the departmental proceeding started?
Started, my lord.
Started.
Started, because the.
Let us see this order that you are challenging, 3/3/23. What is this?
Impugn order 20, page 21. Page 21.
Yeah, Mr. Council, why are you telling lies?
My lord, I have.
This is a suspension order. Huh?
Can be taken by the appointing authority, my lord.
Can be taken by the appointing authority?
Appointing authority.
Mr. Council, the disciplinary authority will decide.
Disciplinary. My lordship, district elementary
Right.
education officer is not
Heard
disciplinary.
Mr. S.H.A. Laskar. Learned counsel for the petition. Also heard Mr.
G. Pegu, madam.
G. Pegu.
Respondent number 1, 2, and 3.
Yes, counsel for the
all the
respondent number 1, 2. 1, 2.
All the respondents.
Counsel all the respondents. The petitioner's case is that he is an assistant teacher in the Bakri Hawar MV school under Hailakandi Education Block. And was temporarily posted to Sushil Paul MV School, provide order dated 27/9/23. The petitioner was placed under suspension pending draw of departmental proceeding. Provide order dated no. The petitioner was placed under suspension. Provide order dated 21/6/2022. Pending draw of departmental proceeding. However, provide order dated 3/3/23. The petitioner has been reinstated into his original place of posting. Which is in compliance with the order dated 9/1/23 passed in WPC 749 of 2020. Full stop. The petitioner has, by way of this writ petition, prayed for setting aside the impugned order dated 3/3/23. What 3/3/23 are you challenging? Huh?
Yes, ma'am.
Which is this page?
Page, my lordship, it is on. Page,
Huh?
21.
21.
21. In as much as my lord.
That is not your prayer. Acha, okay. Who had appointed you?
My lord, my appointing authority, director of elementary.
Huh?
Disciplinary authority is also director of elementary education.
Where's your appointment order?
Appointment order, my lordship, I have not any, but director of elementary education is the appointing authority, my lordship.
Where is your appointment order?
Appointment order, I have next one.
Inasmuch as the district elementary education officer Hailakandi has been requested to take necessary steps for withdrawal of departmental proceeding against the delinquent, against the petitioner, and submit finding of the departmental proceeding to the DESM urgently. Who is the DESM?
Director of elementary education.
To the Director of Elementary Education ASAP. Pusta. Where is your appointment order?
Appointment order, my lordship, but I have not annexed.
Yeah, next, right.
It's,
There is nothing in the writ petition to show who has appointed the petitioner. And as to how the order dated 3/3/2023 has caused prejudice to the petitioner. As such, the petitioner has not been able to show
my lord,
as to how he is an aggrieved person in pursuance to the order dated 3/3/2023. The above being said, next para. No, next para. Next para. Mr. G. Pegu, Learned Counsel for the Elementary Education Department, has on the other hand submitted a notice dated 18/3/2025 issued by the Joint Director Elementary Education Assam to the Block Elementary Education Officer Hailakandi and the petitioner, informing them that a hearing is scheduled on 25/3/2025 in the office of the Joint Director Elementary Education Assam regarding withdrawal of departmental proceedings in respect of the petitioner. The petitioner is accordingly directed to, was accordingly requested to attend the said hearing on 25/3/2025 at 11 a.m. with all relevant records and documents for verification. On considering all the above issues, this court does not find that any prejudice is caused to the petitioner. Further, Where's the show cause notice issued to you? No show cause notice issued to you to them. Has show cause notice been issued to you?
Yes, my lord.
Where is that?
The so-called notice, my lord, Director of Elementary Disciplinary Authority did not issue any so-called.
So no show cause issued to you by anybody till date.
My lord.
Then further, there is nothing in the writ petition to show that any show cause notice had been issued to the petitioner. With regard to the departmental proceeding to be initiated against the petitioner. As such, until and unless a show cause notice is issued to the petitioner and the petitioner is given a chance to make a representation against the same, comma, this court fails to understand how, as to how the impugned letter, impugned order dated 3/3/2023 can cause any prejudice to the petitioner at this stage. So stop. In view of the reasons stated above, this court is of the view that no case for setting aside the impugned order dated 3/3/23 is made up. The writ petition is accordingly dismissed. So stop. However, any order that may be, however, in the event the departmental proceeding is initiated against the petitioner and the same is decided. No, and the result of the DP is against the interest of the petitioner has the liberty to make a challenge to the same as per the writ petition is accordingly dismissed.
Highly obliged. Very obliged. I'm very sorry to interfere at this stage, Lordship. When item number 19 was called for, Lordship,
19, yes.
I was attending a executive meeting, Lordship. That
Yes.
so, Lordship, Lordship has said that non-appeal, that may, Lordship.
Okay, instead of item
number
20 is item. Huh?
19.
Okay, we'll change.
Then non-appeal word.
We'll say that you came late. No, we'll say that. No problem. There was no order passed. Nothing was there. That's all.
No, they say the non-appeal for the petition.
You're lucky you're not here. Lucky you attended the meeting. Anyway.
Obliged.
Yes,
May I please, Your Honor? Your Honor, my
pension,
pension, Your Honor.
pension, yes. Who is the council?
I am appearing for the secondary education department manager. So my lord, here. My lord, here some modification regarding his salary or has done, and as per my instruction, a partial modification order dated so and so, dated the petitioner was allowed to draw the scale of pay rupees 650 to 750 80 25 1000 per month with effect from the date of joining 8/12/1988. The service of the petitioner was confirmed as a stenographer by IS and this is.
Okay, why are you not giving the pension? Just read that report, the relevant portion.
My lord, now it is sent for the government of appeal.
Show me that, show me your instructions.
Some excess drawal was there.
Huh?
Some excess drawal was there.
But you're not telling the petitioner anything.
My lord, this is the report from the internal audit also, my lord.
look, unless you all decide either this way or that way, the petitioner has got no, doesn't know which way to turn. If you are going to claim recovery of the excess drawl, then what is he going to do? You have got to take a decision whether you are going to claim.
Madam, that is under scrutiny. But
And the scrutiny since when?
Madam, in my instruction at S2, my lord, now Inspector of School Nalbari has submitted a letter to the Directorate of the Secondary Education, letter number so and so dated 28/4/2023.
28/4/23.
Yes.
And now it is, what is today's date? Today is March 25. That is March 23. 2 years have passed.
Madam, a hearing in that respect, a hearing also conducted. In the second line, the hearing report was sent to the government by letter number so and so dated 4/5/2024, seeking necessary instruction for further course of necessary action. Subsequently, a government letter is received by so and so dated 29/11/2024, where sought for the views of internal auditor of the director, to which is a reply is no, which a reply is provided by letter number so and so dated 6/1/2025. Meanwhile, the petitioner retired from the service 31/3/2024. The Inspector of School Nalbari has also sanctioned the provisional pension and GIS benefit.
No, Mr. Counsel, you have got to take a decision.
Yes.
You cannot keep on saying that you are waiting for reply, seeking comments. That will not do.
Well, sometime may be granted so that I can obtain the up-to-date instruction, my lord. regarding-
Otherwise, the director will have to come here and personally explain why things are just being kept in the view stage, views of this, comments of this.
One my lord, last chance may be given to receive the up-to-date instruction, my lord.
Mr. U. Sharma.
Yes.
Learned Counsel for whom?
Secondary Education Department.
Secondary Education Department has submitted 2 letters dated 6/1/25 and 21/25. 201/25, okay, 20. Issued by the Director of Secondary Education, which is to the effect that a decision is yet to be taken regarding the excess drawl of salary of by the petitioner amounting to rupees 21,55,085. Full stop. He submits that it's because of the excess drawl of salary that the pension of the petitioner has not been finalized. Mr. U. Sharma shall obtain instructions from the director and the secretariat of school education as to why a decision has not been made by the authorities regarding the procedure to be adopted by it with regard to the alleged excess drawl of salary by the petitioner. List the matter on.
Lordship, date may be fixed. Nine.
May please your lordship.
You claim to be the first wife
Yes, sir.
and family pension has been given to
Private respondent, this second person.
and who's for the private respondent?
Falafnama has been.
You are for the private respondent?
Respondent number 9.
That's the point number 9.
We have filed.
According to you, are you the first wife or the second wife? Oh, yeah, what? No, in your affidavit, what have you said?
We have not filed the affidavit.
Okay, forget your affidavit. You go and talk to your client now. Ask her on the phone. Is she the first wife? Or is she the second wife? And whether the petitioner is the first wife or the second wife? Or not a wife at all? Can you ask over the phone and just then we can dispose it of no point keeping this
Lordship,
pending.
Annexure 2, it is already this has been decided by the court below, your lordship, in a divorce case.
Acha, there's a
Yes, Lordship.
acha, divorce.
Annexure 2,
Anyway, that's a
Annexure 2, page number 27, your lordship. That may be
annexure 2, page number.
27, your lordship. Title suit number 134 of 2022, your lordship.
So this Nazma Begum Laskar is the respondent number 9.
9, lordship. Second page, page number 28, your lordship.
28, yes.
Fourth line from the top, your lordship.
Yes.
Fourth line below from the top. The plaintiff thus was deserted from his own residence and he took shelter in the house of his relation near Kuchila Bazar. Then purchased some land and thereafter married to so-and-so Salma Begum Chaudhary. She is the respondent number 9. And he is also happily living with her in his second matrimonial life.
No, Nazma Begum is the petitioner.
Salma Begum Chaudhary.
Mr. Counsel. The petitioner in this writ petition, today's case.
Yes, Lordship.
What is the name? Nazma.
Begum.
Nazma.
And Lordship.
Nazma. And this page 27, the plaintiff is Moinul Haq. Who's you?
Moinul Haq is the deceased husband.
Husband.
Yes.
Versus Nazma. Nazma is you.
Nazma is me, your lordship. And he is stating that Salma Begum Chaudhary. Salma Begum Chaudhary is the second wife. That's number 9, lordship. Nazma, me. Salma is the private respondent, second wife, lordship.
Okay.
And now, lordship, may kindly see page.
So as per his, so what has happened to this title suit?
Lordship, kindly see page number 42. And
the suit of plaintiff is dismissed.
Dismissed. The marriage between the plaintiff Moinul and the defendant Nazma Begum
Stands.
Then the decree part is at page number, lordship, relevant portion is at page number 45.
Yes, madam.
Decree.
Lordship, can you give me some time? I'll ask my senior.
Where is he?
He's
In that event, I have no objection. But
he's lagging court number 9, your lordship. I'll call him.
What is his name?
Anish Borobia.
Please call him.
In this matter, we have received some instruction, but that is not sufficient to file. So we need some time with it. And IA has also been filed on 17th.
IA, my lord.
Then
Paying
on,
for releasing our salary. My
on
current salary.
17th, we need to reply to that also. This affidavit will cover in both lotships. So at least 3 weeks time may be granted.
My lord, I am not with any salary, my lord.
You'll get your salary depending upon whether your writ petition succeeds.
Yes.
Supposing your writ petition this is dismissed, then what happens?
Yes, that is.
Then you'll be getting free money.
But I am discharging my service. My lord.
Maybe, but you have not been asked to discharge.
Yes.
There is a status quo order.
Status quo order.
Yes, they will.
Status quo order. You've got to.
2024, my lord.
The status quo order.
On the basis of that order, my lord, I am presently discharging my service, my lord. And from 1/11/2024, I have not been paid any salary. My lord.
We will find reply to their IA also.
Okay, Mr.
Update may kindly be.
AR Tahbildar.
A.L. Tabildar, Learned Counsel for the
Higher Education Department.
Higher Education Department is granted
3 weeks time.
3 weeks time to file affidavit in opposition. Mr. P.D. Nair for
Respondent 3 and 4, Cotton University.
which is point 3 for are you filing?
We
No
must
affidavit.
file, my lord, because the issue, my lord, needs some examination. So on the
You will be
notice,
filing also.
We will also be.
Appearing for Cotton University submits that he will also be filing affidavit within 3 weeks. Mr. Filing?
Our part become later on.
Mr.
First, the government.
Okay. Mr. Swenso for the point number 5 submits that he also needs time to file affidavit. List the matter after 3 weeks.
I pay for a date, my lord.
As far as my.
Give a date.
My lord, my submission within 3 weeks, my lord, could it be after submission of the government?
Because they are employees of the government discharging isn't.
You give exact 3 weeks. 9th April.
Reply of that.
No, it's only for filing affidavit.
Let an interim order will kindly be continued.
Interim order to continue till the next date. Should it continue? Anyway. That is the issue to be decided, actually.
Whether after 60, my lord.
Yes.
Yes. 28th, my 28th. I've been told that on 9th, my lord, my senior will be not here, my lord. Can you-
No, anyway, we'll let the affidavit be filed because he'll want to file again. Item?
Maybe, find the order dated 25/2/2025.
Yes. Madam,
Your lordship, pertaining to that, your lordship, instruction is still awaited, your lordship. Kindly grant us 2 weeks' time, your lordship.
That's 13 years, my lord, petition is spicy.
At the instruction is Susan.
madam, what to do? Do we, unless they take a stand, if they don't take a stand, we have got to take a
I
stand.
will be filing affidavit. Your
No, I don't want affidavit. I just want, yes, it has been considered and taken a decision this way or that way. That's all.
Only.
Otherwise, I'm going to call your people and
Will be filing our affidavit, your lordship.
no, I don't want affidavit.
Instruction by Monday, your.
It's like this. It's like this. He wants, you see, a decision has to be taken by the state level scrutiny committee. We will call the secretary we will call the secretary.
Your lordship, I'll obtain instruction by Monday itself.
Obtaining instructions will not do. They have got to take a decision.
Yes, your lordship. Whether he will be provincialized or not.
Yes, that's all. Yeah. You can take a decision there and you can say that, oh, he's such a nuisance. Let's give it to him. Or he's such a nuisance, let's not give it to him. Either way, take a decision.
Yes, sir.
Ms. P. Das, Learned Standing Counsel for the Secondary Education Department, submits that the state level scrutiny committee has not considered the case of the petitioner for provincialization in terms of the order dated 17/9/2024 issued by the Director of Secondary Education. Which is reflected in the order dated 27/1/25, passed by this. It is also noticed that despite more than 6 months having lapsed from the date the director had issued the order dated 17/9/2024, the state level scrutiny committee has not considered the petitioner's case till date. Accordingly, last chance is provided to the respondents to ensure that the petitioner's case is considered in terms of the director's order dated 17/9/2024 by the next date. Failing which some strict orders may be passed. List the matter on. When can you do it? We'll give you some time.
1 week.
We'll give you more than that also. Today is 19th. 26. List the matter on 9th. You do it by night, madam.
Yes,
If
sir.
you don't do it, then
Yes,
they might not have a very happy view.
Page 22.
Item?
My lord, in this matter, my lord, I was directed to produce the original record mark sheet of the respondent of 4 and 5.
Yes.
My lord, can you grant 1 week time already? I have communicated. They have given some other instruction. 1 week time.
Okay, right. This is the case where that counsel said that
Yes, yes.
that he has been asked not to appear. Right.
It is a date may kindly be fixed.
Right. Well, let me record his statement that way. Mr. A.H.M.R. Chowdhury, correct?
Yes.
Third counsel for the petitioner pays for adjournment. Inasmuch as he has been informed by the petitioners that they are going to engage some other lawyer. Full stop. On the prayer of on the prayer of the petitioner's counsel, list the matter on. List the matter on, give a date. 7. Full stop. It is hoped that the petitioners would have engaged a new lawyer by that date, inasmuch as the matter had been fixed for disposal today. Full stop. Mr.
GP.
Ms. G. Pegu shall bring the original mark sheets of the petitioners and the.
That original mark sheet are with the respondent, but I can give the uploaded copy of that mark sheet. Which
Respondent?
subject matter? Respondent 4 and 5.
Actually, at the time of application, it was uploaded through online.
Can you bring the original, then you bring it?
Yes, sir. Ready?
Oh, I will,
Yes, you bring it. You are who? Who are you?
I'm respondent number 4 and 5.
Who is that?
Yes, sir.
Selected candidate.
Selected candidate.
Acha. Why is it with them?
No, it is in the department. At the time of application, I have already submitted.
Huh?
My lord, uploaded copy is there. Original is with the respondent number 4 and 5. my lord.
Original copy of the mark sheet
Mark sheet here.
with them. Acha, okay. Okay. Yes.
No, original.
Mr. G. Pegu shall produce the uploaded
Yes.
copies of the mark sheets of the petitioners and the response number 4 and 5 on the next date. So that is already here in the records also.
No, my lord, that
Affidavit has already been filed. No, department. Respondent number 2.
Not that. Okay. Huh? You give the date. Huh?
Yes, your lordship. My lord, I am actually sorry, my lord, because. due to
28, yes.
So lordship, what happened, lordship, the respondent number 9, lordship, who married to the lordship with the husband with her husband, lordship, after divorce, the petitioner. lordship.
After divorce, the petition.
Yes, lordship. So the lordship, lordship, second wife, that theory does not
That
count.
does not come in.
Yes, lordship. Because
But according to him, there was no divorce.
lordship, according to them, lordship, because lordship, throughout his life, lordship, I am with him. It is admitted fact that since 2013, when the husband of the petitioner was retired, they have some lordship chaos and there are court case pending, lordship. So in all such circumstances, lordship, the
For all practical purposes, you are the wife.
yes, lordship. So divorce was in the year 2007, lordship. Thereafter, he married me, lordship. So anyway, lordship, now today, lordship, I may pray for some time, lordship, so that I can file a detailed affidavit, lordship, stating the entire facts.
No, you just come to this thing. You just come to this page,
Lordship, page 27, annexure 2.
page
Three cases has-
27.
3 cases has been filed against me by my husband.
Anyway,
In all the cases, this issue has been framed, whether there is a divorce or not. In all the cases, issue is
Lordship,
Negative.
whereas,
where is the, you come to page 42.
This is the order part and decree is at page number 45 below. Decree is in page number.
That
45.
is regarding maintenance part, lordship. So it is admitted fact, lordship. Besides, if divorce is also happened, lordship, then also maintenance is required.
This is there, please read, please read. This is in English. It's not in Greek.
Yes, lordship.
Please read, what does it say?
Yes, lordship, that the marriage between the plaintiff Moinul Haq and so defendant Najma Begum Majumdar stands. And the
Stands,
plaintiff
it says stands.
Yes, lord, stands.
Marriage stands.
And then page number.
It stands means what? Does it mean divorce? Does when you say the marriage stands, does it mean that the marriage, it's a divorce? What, you please show me, if there is any different meaning to that word stands.
Lordship may kindly produce page number 44, Lordship.
44, yes.
44. This is the decree in connection with the same suit, Lordship. Page number 44. Decree, and now page number 45, order. With regard to the decree, Lordship.
So you see, the problem is, I understand your issue.
So,
But probably that, okay, he didn't want to live with the petitioner anymore. No problem about that. But the problem is the law as it is, as has been declared by the lower court, is that there is no divorce.
Yes, lordship. So,
Then-
lordship, for that purpose, lordship, I may pray because lordship,
There's nothing to pray.
lordship, only
There's only thing if you're going to say that there is a divorce, you've got to show me some document, that's all.
lordship for that purpose, because today first day,
Okay.
lordship, it
First
is
day?
listed lordship.
Lordship,
After notice,
in that
lordship.
case, Lordship, kindly.
Lordship, after notice, it is first listed lordship. So kindly, lordship, I will pray lordship for accommodation some lordship.
No
After-
problem, we'll give you time, but you just calculate, just see.
Lordship.
I will
Small,
produce.
small prayer, Lordship. Last occasion, on first occasion, your Lordship, there was a rider that interim will be considered on the next returning
Ah.
date, your Lordship.
No, that we will stop.
Lordship.
Family pension has to be stopped.
Lordship, only I am for accommodation of 2 weeks time. lordship.
We'll give you 4 weeks also, no problem. But family
Because,
pension is
lordship,
stopped.
I have also right, lordship, because
You have a right.
if lordship,
Yes,
then
I am not
pro-
denying that.
pro-
You see, Mr. Council, there's no question of proportionate.
Yes.
But as per that full bench judgment, she has got a duty to maintain you.
Yes.
She has got a duty to maintain you. So family pension will be in her name, but she has got a duty to maintain you. So she will not get everything. She has to pay you all.
But
That
after consideration of that full bench judgment, lordship, there are so many judgments come, lordship.
anyway, that does not matter
proportionate-
unless you can show me a Supreme Court judgment or a judgment of an equal strength, full
Yes.
bench judgment. Division bench judgment will not do. You have to give me a full bench judgment or a Supreme Court judgment. That's all.
I will produce.
And in any event, the divorce is not there. So in fact, that full bench judgment is, you're lucky that it is there. Otherwise, you'll get 0.
In his lifetime, lordship, because she had no connection with, and even in her
Correct.
his
But
last
what to
time,
do?
lordship,
You see,
I am there, lordship.
you see, that is the problem that we judges face.
Yes, yes.
You see, sometimes you see, say in POCSO cases, they have got kids, but they are below 18 years.
Yes, lordship.
They are married. But then the law has to be upheld. What to do? We also have got some sympathy for them, empathy for them. But what to do? The law is like that. Here also, most probably your husband didn't love her anymore. Probably she was not very, kind to him, did not look after him. Maybe, we do not
She's
know.
looking after all.
Maybe, yes.
all-
And then all the hard times fell upon you.
Yes, lord.
But death happened and then she said,
Suddenly
I have
became
I have
lordship
to
and
get
now
all the
take
money. Correct. Now what to do?
So for that purpose, lordship, I pray lordship for some time, lordship.
We'll give you next week. That's all. You bring the original of this decree,
This is certified. Lord.
certified copy.
This is the certified. Lord. I have annexed the certified. Lord.
No, you have not next certified. Maybe in your copy, not in mine. Mine is just certified to be true copy by advocate. You give me the certified copy, let me see.
Yes, okay.
You bring the certified copy, right? Huh? Mr.
R.H. Choudhury.
R.A. Chowdhury appears for the petition. Mr.
NH Borbuya.
N.H. Borbuya appears for the respondent number 9. The petitioner's case is that she is the first wife of the deceased husband of a deceased husband, and as such should be given the family pension. However, the state respondents have granted the family pension to the respondent number 9, who is the second wife. Next para. The petitioner's counsel submits that the petitioner's husband had filed title suit number 134 of 2012 in the court of the Munsif number 1, Hailakandi, praying for a decree to the effect that the marriage that a divorce had taken place between the petitioner and her husband. However, the title suit number 134 of 2012 was dismissed while judgment dated 19/11/2018, and a decree was also issued on 36/2016, no, on
Same day, 19/11/2028.
19/11
2028.
2028. Full stop. The counsel for the respondent number 9 is given a week's time to produce documents to show that there was a divorce between the petitioner and her late husband, and that the judgment passed in title suit number 134 of 2012 has been set aside by an appellate court. The petitioner's counsel shall produce the original decree in respect of title suit number so and so on the next date. List the matter on, gives a date.
My lord, can I pay for 4th of April, lordship? Because
Okay, 4th of April.
kind of like.
It's maybe not
Miss,
as they.
as they appears for
Seven.
respondent number 6 and 7. Who are they?
Bank.
Bank.
Pension process.
Respondent.
So one small observation, on next date, my interim is not there. but-
Okay, wait, interim. On considering the fact that there is a decree which had dismissed the petitioner's title suit, the state respondents are directed not to disburse the family pension to either of the parties
Obliged.
till the final decision is taken by the court.
Obliged.
My lord, by last order dated 21/2/25, lordship was pleased to issue notice both on the main writ petition as well as on the interim prayer. It's a case where the petitioner has been suspended for the second time. First time, my lord, he was suspended, then it was withdrawn, then I was reinstated. Now again, my lord, based on the same nature of allegation, now, my lord, whereas disciplinary proceeding has not been initiated till then. And my lord, my humble submission is suspension cannot assume the character of punishment. Purpose of suspension is not to punish somebody.
Correct.
So now, my lord, one suspension was resorted to, it was revoked, reinstated. Now again, I have been suspended. If it is not punishment, what else it is? Whereas in the substantive proceeding, we have not taken any step. Suspension is not meant for these purposes, madam.
Lordship, I file Lordship. Lordship, I file for trying for impleasement
Implement.
as a respondent number 4, Lordship.
Well,
I am
is
the
the-
president of the governing body.
No, my lord. Whether he implicates or not, that is not the issue. Issue is just a question of law, my lord. Whether you can again suspend me once having revoked. What is that?
No, that's what we see. Is your application allowed?
Yes.
But yes,
Lordship, here we need to file affidavit and this, the second time suspension is not on the same issue. In the, there, also that has been, the president has lordship stated.
okay, just a minute. Let me finish his, okay? Heard, mister? Huh? P?
Boiragi, my lord.
Your name is not here. Okay. Boiragi, learned counsel appearing for the applicant. Who's, applicant, no? Who submits that the applicant may be pleaded as respondent number 4 in the writ petition. Mr. K. N. Chaudhary, learned counsel appearing for the writ petitioner, and Mr.
They are talking that.
A. R. Tabida, learned counsel appearing for the
Higher education department.
Higher Education Department.
Number 120.
Submit that there was no objection to the application being allowed. Full stop. In view of the above, the applicant is pleaded as respondent number, so. The applicant shall submit a corrected copy of the cost title to the registry within a period of 2 days. 2 days, huh? This, that's all. The I is accordingly allowed and disposed of. Then in the main case, you write, in view of the order dated, today's what date? 19/3/2025, passed in IAC 762 of 2025. The applicant, so and so, Professor so and so, is pleaded as respondent number 5. Issue notice, no, that's all. Mr. So and so, appearing for the respondent number 5 is granted. 5, no? 5 or 4? 4. Respondent number 4 is granted. How much time to file affidavit? 2 weeks time to file affidavit in a province. Okay, yes.
We'll also file affidavit. And
So your case is that
second time suspension is lordship on another issue.
on another issue.
Yes, on
The first suspension was in relation to embezzlement of scholarship funds.
Yes.
Then what was the second?
Second lordship, that will have to obtain at pace.
And on what
Case
basis
five.
my learned friend is making
Yes, I
submission?
am making the submission on the basis of the lordship, the IA. That at paragraph 5, it is stated that the applicant wishes to state that on 15/4/24, IA, in the IA. And on page 5 of the IA, paragraph 5. So we'll have to ascertain lordship. That the applicant begs to state that on dated 15/4/24 and 25, a local conscious people of Uttar Barpeta College filed
No,
complaint.
this is different. This is, look, you have got to stand on your own legs.
Lordship.
Let us see the suspension the suspension order is
yes.
of,
Suspension order is at page, my lord, 54. Whereas an inquiry committee was constituted by letter dated 23/10/24 to inquire into the matter of financial irregularities alleged to be committed by so and so principal cum DDO of Uttar Barpeta College, Barpeta, as per the preliminary inquiry report dated 23/11/24. From the inquiry committee comprising of so and so and so and so, financial irregularities have been committed by principal. Therefore, the undersigned is satisfied that it is necessary to place Mr. Zahir Ali under suspension from service with immediate effect in the interest of public service. Now pending trial of the departmental proceeding, Mr. Zahir Ali so and so is placed under suspension under Rule 6(1) of the service code. Now, my lord, if your lordship would kindly come to page number 9 of the IA. Page number 9 of the IA. That
Yes.
madam, controversial principal, Zahir Ali continues his corruption again. The college was provincialized by the government however, since 2013, we have noticed that he has been involved in continuous scam of government fund and owns a lot of property since 2013. 40 lakh has been collected every year in the name of admission. And we know that crores of rupees have been donated by government at various times in the name of college.
About 45 lakh has come from UGC fund. The late Chief Minister Tarun Gogoi had donated about 15 lakh during his tenure, but he has not accounted for any money. The college received 1 crore from the government of Assam, but no one knows any account till date. Madam Controversial has also allegedly embezzled student scholarship money in the name of student many years ago. Now, my lord, these are the allegations. Now, my lord will kindly come to the UGC's letter at page number 34 of the writ petition. Everything has been audited, my lord. There is no, some people are after me, that's all. Kindly come to 34, my lord. Now, this is the undersecretary of the UGC writing to the principal. This is in reference to your letter dated so-and-so on the subject cited above. In this regard, it is informed that no student was selected from Uttar Borpeta College, Assam, under Ishan Uday scholarship for any year in so-and-so, so-and-so. Also, no scholarship amount has been processed to the student of this college under this. My lord, these are all allegations of 2013, my lord. Now they are rewriting again and again. And at that stage, my lord, where is the question of getting crores of rupees grant by the college, my lord? Everybody knows, my lord. What does a cancer institution, how it stands, my lord? My learned friend has no instruction of his own. And reading, going through the, my lord, this IA.
I'll file lordship application.
No, you can file. We are not objecting to that. You can always file as every right. But when you make a submission that I am involved in financial, that means you are imputing your own knowledge.
Lordship, this is.
Then we'll cross-examine you.
This is initially his suspension was withdrawn, then he was made principal in another college. Thereafter, he was again posted to the initial college, the origin college. Then thereafter, he has been again suspended on some on other allegations. So
How can there be other allegations? These are already indicated.
We'll clarify, lordship.
You see, the thing is that we had issued notice
Yes, lordship.
on February,
Ah.
21 February.
Yes, I have a written letter to, but we could not get the instruction.
This is for an interim order.
I have communicated with the department, lordship, for the
If they are not interested in answering this,
lordship.
if they are not interested in answering to our orders, then why should we wait for them?
Lordship, at least 2 weeks time, maybe unpaid lordship, because we have communicated from our end, we have communicated with the department. Today also we have reminded that the matter has been listed. Okay.
My lord, another aspect I'd like to highlight, my lord, if your lordship would kindly come to page 53. Now, this secretary, he writes to the then director, take action against the petitioner based on those complaints. Now, my lord, what it so happened, when the director was on leave, then he himself passes the order, my lord. The impugned order at page 54. What is his interest? Now we understand he has been removed. He has been removed from that post. This Noyan Kumar Pathak,
may be transferred out or something.
whatever it is. No, my lord, kindly see, he is writing to the director based on some complaint of somebody, take action. First you inquire, first thing is, my lord, if there is allegation against somebody, then that inquiry has to be inquired into, then only question of taking action comes. My lord, my humble submission is, these are all old and stale complaints, my lord. These have already been gone into, this honorable court has already passed order for my reinstatement. Now, my lord, after order of this honorable court, how can they do this, my lord? In fact, at page 39, the order of this honorable court.
Has the departmental proceeding been initiated?
No, nothing. Neither in the first case, nor in this later case. And if your lordship would kindly come to page 40, my lord. While saying that the suspension is withdrawn, serial 3, respondent 2 is further given the liberty to prohibit petitioner from contracting any person handling records and documents till the stage of preparing his defense. This court too further grants liberty to the director to transfer the petitioner to any of its office or colleges under its authority so as to serve any local or personal contact that the petitioner may have, which he may misuse for obstructing the investigation. So all this liberty was given, my lord. Till that, no DP. And this is an order of 17/5/2023.
We'll list it next week. We'll give you chance. No affidavit. Just next week. You give me the reason why. That's all.
Yes.
Monday.
What's this? Wednesday, local.
Wednesday, 1 9.
Will matter. That Mr. Goswami, no? Okay. Tuesday, Wednesday.
Wednesday or 28, it will be better. 28.
28 some difficult. Let it be on 26.
Yeah,
you know.
26 you do it, right. Mr.
A.R. Tavilda.
Yeah, Tabilla shall obtain instructions. Shall obtain instructions by 26/3/2025 as to the basis for the petitioner's subsequent suspension. In the event no instructions is forthcoming, the interim order will be, the interim prayer will be considered on the basis of material on the top.
Deep level.
Problem.
Huh? Yes.
It's the instruction to APM. Meter may come after 1 week. In the meter, I will file a pitch. Wakalat na mobile.
You'll be filing?
Wakalat na mobile.
Only Vakaladama.
And instruction also mobile. Please. The meter is active under active consideration.
Similarly situated person already got the
Huh?
area. Similarly situated person already got lordship, area salary. In respect of area salary.
Yes, sir. Okay, right. Mrs. Tutia, submit that she will file a Vakaladnama on behalf of sole respondent and will obtain instructions by the next date. The matter pertains to non-payment of arrears salary to the petitioner. List the matter on,
I need it for the next week.
when do you want? You tell me. You choose the date.
First of. Or either. Fourth, 7 did you know?
You eat, na, eat. You give her a good tiffin, we will get good order.
34 and 35.
This is I prepared for Assam Agriculture University matters. We are seeking leave to declare the results.
Let them declare the result.
What had happened, madam, the court wanted to know that if this assessment which you have done after you have to come to court, if you had applied the same yardstick in rejecting. So court asked me to file affidavit, but without opening the records, how can I file affidavit? So these results are here, madam. Lordship can open this. Seal covered.
So the day of reckoning for you.
Yes, please.
How many writ petitioners?
Two writ petitioners, and two different disciplines.
Huh?
Two writ petitioners.
Item number 30.
So you don't know the result?
No. Because initially they were not allowed to participate. They
Correct.
came before this court.
Item 34 pertains to aquatic environment management, my lord, associate professor.
Ah.
Rajdeep Bappa.
You don't need to be late.
Aquatic. Going to be opened. Let's see what happens.
If the clients are watching.
Either they're going to have laddus or
Yes, my lord, if they are watching live stream, my lord, I think goosebumps are going on, my lord.
Oh, I'm the hour.
Petitioners, my lord.
A petitioner's name out here is.
One is Rasdeep Dutta, 34, item number 2.
Item number 36.
Discipline.
How many posts?
One post. Two posts.
The others have been opened? The others?
No. No. All result, Quadi petitioners, all, everything is there.
This is only for the petitioner. Huh?
One post only. Against discipline, one post.
Yes,
So we do not know if the final thing is there at the side written.
Other one is
Item number 35, Lordship.
the discipline is
Discipline, Lordship, veterinary surgery and radiology.
Okay. This one has got the others also.
because only one post was.
Okay, out here only one post.
Two disciplines, two different posts.
Okay, right. In the IA. In both the IAs, it's the same. Mr. D. Gogoi, Learned Standing Council for the Agriculture University. Praise that the applicants may be allowed to declare the results for the post of associate professor in the discipline of aquatic environment management in terms of the order of this court dated 7/1/2025. That is in 429. 429. 429. Mr. R.M. Decca appears for the writ petition. Who else? And no one else. You're there?
Petition number 35, item number 35, Lordship.
Okay, that's wait. And Mr.
On behalf of PJ Pukal.
Your name? A. Rahman appearing on behalf of Mr. PJ Phukan, Learned Counsel for the Gautam University. Submit that I have got no objection to the application being allowed. Accordingly, the applicants are allowed to declare the results for the post of associate professor in the discipline of aquatic environment management. The IA is accordingly allowed and disposed of. Then in the other case, in the IA 568.
568.
Out here again, Mr. D. Gogoi, same prayer, but it will be in respect of
Assistant professor.
assistant professor in the discipline of aquatic environment. No.
Some, that IA, some, just grab some.
Previous one was for aquatic engineering.
That inadvertent crept in.
Okay, in this 568, it is for,
No, my lord, it's basically there's a different, but the prayer portion, it remained somehow.
oh, you made the
Yes,
mistake.
yes, it
Okay.
was our fault, my lord. But the
Okay.
discipline is
In discipline of
veterinary and surgery and radiology.
veterinary and
Veterinary surgery and radiology.
veterinary surgery and radiology. That is in 568.
568.
Okay. Then after Mr. R.M. Dekha, you're there again?
No, my lord.
No.
My client is appearing.
N?
NK Sharma.
N.K. Sharma, huh? For the writ petitioner. Others will remain the same. Okay, same. Huh?
What university is there?
No, that is again same. How you get it? So the writ petitions also can be disposed of. Nothing else survives.
My lord, our prior rate petition was, my lord, rejection of our candidature, my lord, on some grounds.
So you have been, you have participated now.
Yes.
Yes, my lord, we
So
participated.
your selection, your results are there.
Yes, my lord, but my lord, if we are unsuccessful this time, my lord,
Ah.
next time, my lord, when the post will vacant, they will issue advertisement, my lord, and same conditions will be incorporated. And again, we'll be.
No,
but
then you come again and you say that you are allowed.
in that case, my lord, may I pay for some time to take instruction from my client, my lord, whether he wants to pursue it or not, my lord. Because
This is
that
only of academic interest. This is only of academic
my lord, our
interest. now.
prayer is to, my lord, for set aside that rejection. Or
No, they don't set aside and he was allowed to sit.
You are allowed to
if
sit.
that is set aside, my lord, then my lord.
No, no, it's not,
that
it's
may be
not, it's
recorded.
not that, it's not that, it's not, I'm not on that. Once the issue, once you have been allowed, I am not going into the merits of the case anymore.
lord.
I'm going to say that now it has,
If the, my
it's
lord,
only of academic interest. So
Yes, ma'am.
when that issue comes up again, it will be taken up. That I will clarify here.
yes, liberty may kindly be granted.
Huh?
Liberty may kindly be granted, my lord.
Okay, right. Item, both, I have 4251, huh? 4251. You right, heard, Mr.
4251 Lordship, I am appear.
Acha, you are appearing. Mr. N.K. Sharma appears for the petitioner, huh? So we'll take this first order, I think. So you take this paragraph, this long paragraph, second paragraph, you take this, okay? Then you say, last order. This court, by interim order dated 21/8/2024, directed the respondents to permit the petitioner to appear in the interview for the post of assistant professor in the discipline of veterinary surgery and radiology, pursuant to the advertisement dated 8/2023. Oh, sir. The petitioner, no, this court also in the interim order had directed the respondents not to finalize the selection process till the next returnable date. Next paragraph. The petitioner has accordingly appeared in the selection process pursuant to the pursuant to the interim order passed by this court. In persons to the order dated 19/3/2025 passed in IA Civil 568 of 2025. The Assam Agriculture University. No, the who is it? Which your respondent number? Yeah. In the writ petition?
My lord, That's number two, my lords. One and two, both. my lords.
The respondent number 1 and 2 have been allowed to declare the results of the selection process, including the marks obtained by the petitioner. Pusta. As the results of the, as the result secured by the petitioner. Which one is the one? As the marks obtained by the petitioner for the post of assistant professor in the discipline of veterinary surgery and radiology is below the marks obtained by the, or should I wait for the result there?
Lordship will declare them.
No, what have I said? As the marks are to be declared by the respondents number 1 and 2, as this court has already opened the envelope containing the marks of the candidates, which shows that the petitioner has not been selected as he has secured lesser marks than the other candidates for the said post. This court is not going into the issue as to whether the petitioner could have been barred from participating in the selection process. The same would only be of academic interest as on date. And if and when such a situation arises in the future, the petitioner is given the liberty to agitate the said issue again. The writ petition is accordingly disposed of.
Okay.
Then in the other case,
In other case, interim order was passed on 20/08/2024. And the discipline is,
no, that is not the main case. I've got to again, the problem is I've got to pass the entire
yes,
full thing, no?
425.
Right, heard Mr. R.M. Dekha, learned counsel for the writ petition. Also heard Mr. D. Gogoi for the respondents number 1 and 2, and Mr. A.R. Raman. A.R. Raman. Appearing on behalf of
Respondent number 3.
respondent number 3. No, appearing on behalf of Mr. P.J. Phukan, learned counsel for the respondent number 3. The same thing, same thing, except that it'll be, is it the same?
No, my lord, associate professor.
No, I know, but the reasons and everything for barring,
Yes, my lord.
is it the same?
No, then it will be different, my lord.
Okay.
38 is the rejection, my lord, page 38.
Okay, wait, try this right. The petitioner's case is that the petitioner had submitted his candidature for the vacant post of associate professor in the discipline of aquatic environment management.
Yes.
Under the what university?
Assam
Under the
Assam
respondents number 1 and 2. Under the respondent number 1. In response to an advertisement dated 8/2021, dated 11/12/2023. However, the petitioner received the impugned letter dated 13/8/2024, informing him that his application had been rejected on the ground that he had done his PhD under the traditional system and not under the course credit system. It's all in the synopsis. Full stop. Secondly, no marks were filled up by the petitioner in the column given for PhD, and no credit had been mentioned against the course in the mark sheet as reported by the screening committee. Problem, this cough, I don't know.
Yes. Going on, my lord. Sandstone is going on, my lord. That is well.
Too dusty and then air quality is too poor, man.
Too poor.
Acha.
Yeah.
And then I go for my morning walks, no?
Yes, yes, that is good.
1 minute, huh? Funny. The petitioner's case is that. Let's para. You just take, huh? Petitioner's case is that from here. I'll not use the pen. I'll use the pencil. Further, further. The petitioner's counsel further submits. Ah, then here. Okay. That's. Then C, then after C, huh? At the B will be the further submits, huh? Then after C, the petitioner's counsel also states that, huh? And this part, okay, from here. Okay. Next part. This court, while interim order dated 20/08/24 had directed the respondents to permit the petitioner to appear for the selection process for the post of assistant professor in the
Associate.
discipline.
It was later corrected, my lord.
Associate professor
Associate professor.
in the discipline of aquatic environment management, scheduled to be held on 22/8/2023. Next paragraph. The petitioner's counsel submits that the petitioner has appeared for the said examination. Next paragraph. He also submits that. No, full stop. Next, Mr. D. Gogoi, the learned counsel appearing for the respondents number 1 and 2 submits that as this court, wide order dated 19/3/2025, passed in IA 429 of 2025, has allowed the respondents number 1 and 2 to publish the results of the selection process undertaken for filling up the said post, comma. The same will be published today. Full stop. Will be published. Full stop. Next paragraph. In view of the order dated 19/3/2025, passed in IAC 429 of 2025, comma, this court has also seen the results of the selection process pertaining to the filling up of the vacant post of so-and-so, aquatic field. Okay. This court has also seen that the writ petitioner is the only candidate, is it? He's the only candidate.
No, no, it's
No.
not. Many others will receive.
No, forget that. And this has also seen the results of the selection process undertaken by the respondents full stop. The same shows that the case of the petitioner has not been recommended for the said post. Full stop. Next para, huh? In view of the so-and-so, that order earlier, that academic interest, you.
Diploma.
36. No one appears for the petition on call. No one, full stop, no one appears for the respondents either. In the interest, accordingly, leave this matter after 4 weeks. Yes.